Which room? Which room? Oh, above computer section. IT, yeah. Hello. Yeah, I'm going there. Yeah, I'm going there. I'm going there after this. Okay?
Please, Your Lordship. I beg to mention item number 6 from the hearings list. I'm on behalf of Ms. Nuksong Tila, the counsel for the petitioner. Lordship, here, the pleadings have been completed. However, we have been informed by the parties that there has been new developments. Kindly allow us some time, Lordship.
Button up your coat. Button up your coat.
Apologies, Lordship.
Okay. Both sides are represented on the prayer made by learned counsel for the petitioner. Matter is adjourned today. This doctor. After what? How much time?
After 3 weeks, Lordship.
3 weeks.
For motion, item number
Please, Lord.
1.
Please, Lordship.
Lordship, I just read petition, Lordship. I'm challenging the detention order and the other consequential orders.
Okay. Mr.
More Jamil, Lordship.
Mohajamit, learned counsel for the petitioner. For comment, you are appearing.
My lord, I'm appealing for respondent number 1 and 2. For state respondent 1 and 2.
Mr.
E. Home.
Kitty Wapum, learned counsel for the learned government advocate appearing for respondent number 1 and 2. And who is appearing as CGC?
Lordship, I may be allowed to serve notice upon the respondent number 3. Union of India, Lordship.
No, but I don't understand this practice. The CGC, why you did not serve a copy?
Lordship, I'm told that a copy was served, Lordship. But
No,
Yes,
acknowledgement is not there. You
Yes,
only
Lord.
give acknowledgement to.
I've checked the record and the acknowledgement was not there, Lordship.
Uh.
I may be allowed to serve again, Lordship.
You serve and come. We'll take it out after some time.
Lordship,
You serve a copy and then come.
Lordship. Oblige.
For orders, item number 2.
Please button up your coat. Please button up your coat. Yes. Yes.
My lord, this is a sumo motu transfer petition.
Yes, what do you have to say?
As per the court order, that is on page 6. 7, dated 7/12/2023. This court has asked the PP to give the clarification as to when the rules for administration of justice and police in Nagaland 1937 came into existence. So in my affidavit, we have stated that it came into existence with effect from 14 March 1989. Then after that, the court has asked a query as to whether the chapter 31 of the CRPC, whether it is applicable in the state of Nagaland.
Where is your affidavit? We don't see your affidavit.
Lordship, I filed it on 29/2/2024.
You're appearing for?
The accused persons.
Okay. Yes, what is the
So,
stand?
Yes, the stand of the government is that section 407 of CRPC for transfer of criminal cases, that is not applicable in the state of Nagaland, Your Lordship. That
Okay.
comes under chapter 31. So far there is, that has not been made applicable to the state of Nagaland. So we follow the rules for administration of justice and police in Nagaland. So under section 22C, the government is empowered to transfer a criminal case from one court to another, if on the receipt of the complaint from the party. So Your Lordship, after we receive the complaint.
But you see, you are forcing on the court circumstances which is which is not good for the system. You see, there are two things. Number one, you are invoking these provisions for transfer.
Yes, Your Lordship.
That means you are not respecting the independence of the judiciary. That's one.
Sure.
Second, you see, you have created a system in the trial court where the functioning of the court is not within the control of the judicial officer. The staff are not not placed under the control of the judiciary. Therefore, starting from the peshkar, the peon, everybody, they are not in control of the judicial officers. When we speak to judicial officers outside the court, they say that they can't do anything. The staff of the court just don't come, and they are not the controlling officers. They can't even write ACRs. They can't question them. They cannot. There is no communication channel created by virtue of which the judicial officer under whose court the staff are placed can write to the controlling officers for the ACR. So what is the idea of the government? You have taken instructions. What is their idea? They want to proceed with this, or they want to go back to tribal courts, customary courts?
No, Your Lordship, the question here is a criminal case has been registered.
No, correct. So therefore, you are taking away a file from a judicial officer by an executive action.
Yes, Your Lordship. So now the question before this court is whether that is legal or illegal, Your Lordship. If this Lordship finds that it is illegal, then you can question, set aside.
No, it's a policy decision of the government. And what is the legal position?
Lordship, as per the Registrar General case, the spirit of CRPC and CPC will be applicable in the state of Nagaland, Your Lordship.
So that will prevail
Yes,
if that is a judgment which is in force since 2013.
yes,
The government will have to follow it. The
Yes.
government has no alternative.
true. But so far, there is no notification to that effect that that will be applicable.
No, that is
to-
why,
that is how
that's why
the
as
officer has,
when you are appearing as
passed the
a,
order.
that's why when you are appearing as a public prosecutor, we are asking you, what is the policy of the state? They want the courts to function independently, or they want to, what you call, push the court to a situation where the court is unable to work.
Because, Your Lordship, on the
You see,
report-
here in this state, there is a unique position where there are many forces outside the government who control, who make an attempt to control the society. There are several civil societies, there are several student associations, there are several residents association, there are various religious groups. They all have a lot of what you call clout on the society. Now, supposing a group A starts a demonstration just because an accused is brought to the court, you transfer the proceedings from one place to another. Now, please tell us what is the infrastructure you have created by virtue of which you can produce the witnesses from far off places to another district. What is your timelines to produce the witnesses? What is the nature of assistance you are giving to the accused who will be compelled to appear outside the outside the jurisdictional court?
Your Lordship, it's a murder case, so.
No, murder we understand. You see, it may be heinous of the heinous crimes, but the government must have a policy. Now, please tell us what is the policy on the date. If you have transferred the case to outside the state, how do you ensure that there would be the accused will get due legal assistance? You must have a policy once you are transferring it.
Lordship, so far as the case is concerned, now it's a question of law, whether the state government, they can transfer the matter or not. That's
No,
the
no,
issue.
law cannot be decided in abstract. There must be some factual things
So
before
the
us.
factual thing is that we do not have the notification saying that chapter 31 is applicable in the state of Nagaland. So accordingly, we follow the section 22 of the rules of administration, and under that one, we exercise that power.
Yes, what do you have to say?
Oh, my lord, the question whether CRPC is applicable in Nagaland or not has already been decided in the matter of Registrar General Gauhati Court versus Union of India. If the state is allowed to transfer cases, the independence of judiciary will be at stake in Nagaland. my lord.
Which paragraph of this judgment, 2013, you
Yes,
are
ma'am.
referring to?
Page number 5. Page number 5, bottom right hand side. The page number is at para 16. Para 16, my lord. Page number 5. May I read, my lord?
Yes.
We now take up the case of Nagaland. The Nagaland Judicial Service Rules 2006 have been promulgated almost simultaneously with Arunachal Pradesh Judicial Service Rules, and judicial officers have since been appointed to man the courts. The Civil Courts Act has to be held applicable to the state of Nagaland, also on the same analogy. And further at para 17, now here the question. This is the main question here. Only further question which survives for consideration is whether the trial of cases by courts manned by the members of judicial service, manned by the members of Nagaland Judicial Service, CRPC and CPC will be applicable, though the said court have not been expressly extended, as has been done under the Act 2009 Acts in the state of Assam and under notification dated 24/10/2011 in the state of Arunachal Pradesh, and by the separate enactment in state of Mizoram. The proviso of section 1, subclause 2 of CRPC read as follows. Provided that the provisions of this code, other than those relating to chapter 8, 10, and 11, thereof shall not apply to the state of Nagaland. But the concerned state may, by notification, apply for such provision or any of them to the whole or part of Nagaland or such tribal areas as the case may be, with such supplemental, incidental, or consequential modification as may be specified in the notification. Now, my lord, coming to para 20.
Yes.
We are conscious that under Article 371A of the Constitution, no act of parliament is to apply to, number one, religious and social practices of the Nagas. Point number two, Naga customary law and procedures. Three, administration of civil and criminal justice involving decisions according to Naga customary law. Number four, ownership and transfer of land and its resources. However, we do not see any conflict in applicability of CPC and CRPC to proceedings in respect of matters to be tried by regular courts manned by judicial service. Then further, my lord, coming to page number 10 at para 31. Para 31 and 32, page number 10.
Yes.
It is thus clear that if legislative intent is to bar applicability of CPC and CRPC to customary courts or courts manned by executive officers, the said bar cannot be held to be applicable to regular courts, my lord. The said bar cannot be held to be applicable to regular courts. This interpretation will be harmonious with the functioning of regular courts under the Civil Courts Act and also customary and executive courts under the administration of justice rules. Accordingly, we hold the Bengal, Agra, and Assam Civil Courts Act 1887 is applicable to the district of Dima Hasao and Karbi Anglong in the state of Assam and the state of Arunachal Pradesh and Nagaland. The administration of justice rule applicable in the state of Nagaland and Northeast Frontier Administration and Justice Regulations 1945 applicable to the state of Arunachal Pradesh will give way to the provisions of the civil courts, my lord. To the extent of inconsistency in relationship or functioning the courts manned by members of cadre of judicial service. Now coming to para 32, my lord. We further hold that CPC and CRPC are applicable to the regular constituted civil and criminal courts without in any manner affecting operation of Article 371A or the functioning of village, customary, or any other courts other than those regular courts, regularly constituted civil and criminal courts in the state of Nagaland, manned by members of judicial service. So, my lord, through this judgment, CPC and CRPC are very much applicable in the state of Nagaland, where the regular courts manned by the judicial officers.
Yes, madam.
Lordship, accordingly, we received the complaint from the victim sister that fair trial will not be conducted in Mokokchung, in the court of Mokokchung, because it's a very sensitive issue. And accordingly, the department has also sent a letter to the SP, DC, and the APP of Mokokchung district to give its suggestion, Lordship. So they all stated that it's a sensitive issue, that it would create much problem, that fair trial will not be administered in that area. So accordingly, the Secretary has passed the order dated 13 October 2023, transferring the case from District Court Mokokchung to the Principal District and Session Judge Dimapur, Lordship.
Who's appearing? Anybody is appearing for the victim?
And Lordship, the reason why we have taken the step is mentioned in paragraph 4 of my affidavit.
Is notice served on the victim? Here we see that there's a order of the court of 2/11/2023 issuing notice on the informant victim. Steps was taken, but service report is not there. So we would request the state to serve notice to the informant or victim through the officer in charge of the jurisdictional police station. Correct? Because they are required to be heard in view of the stand taken. You are taking a stand that this is a political murder,
Yes.
and you are saying that the accused persons are in majority in that village, and the victim is a minority, and they are trying to be dominated. That is your stand. Okay. Your name? You are additional AG.
Yes.
Her Miss V. Sukori, then additional advocate general. As well as you are Mr. A. Sophie. And Mr. A. Sophie, learned counsel for the accused. Next, this matter has been placed before the division bench pursuant to order dated 29/2/2024 and administrative approval of Honorable the Chief Justice. Next, the reference was made to the division bench on account of a question of law which arose in these proceedings as to whether in exercise of powers under Rule 22 capital C of the Administration of Justice and Police Rules, 1937, the state authorities to transfer a proceeding, a criminal proceeding, and whether such transfer, and whether such exercise of power would amount to interference with the jurisdiction of the High Court under the Constitution of India. Next, the Learned Additional Advocate General has submitted that till date, Chapter 31 of the CRPC has not been made applicable in the state of Nagaland. And accordingly, she has justified the invocation of powers under Rule 22 of the Administration of Justice and Police Rules, 1937, for effecting transfer of the criminal proceedings. She has submitted that the trial relates to offense of murder. It is submitted that the victim is a minority in the concerned area, and that the accused persons are in majority, and therefore the majority community is trying to dominate the victim's family, who are being threatened, and therefore impartial trial. Cannot be effectively ensured. Next, per quarter, the learned counsel for the accused has referred to the decision of the division bench of this court in the case of Registrar General, Gauhati High Court versus Union of India and others. Thousand 13, then packet 4, packet was GLT 1109. It is submitted that by virtue of the said decision, the provisions of CRPC are applicable to the regularly constituted criminal courts without in any manner affecting operation of Article 371 capital A of the Constitution of India, insofar as the functioning of village, customary, or any other courts other than the regularly constituted civil and criminal courts in the state of Nagaland, manned by members of the judicial service. Next one. Therefore, it expressly appears that the provisions of CRPC would be applicable to the regularly constituted criminal courts. Next one, be that as it may, it is noticed that this court by order dated 2/11/2023, the single judge of this court by order dated 2/11/2023 had issued notice, amongst others, on the informant of the victim. Office note dated 7. Sorry, it is 23/11/2023, indicates that notice was issued to the informant of the victim as well as on the accused persons. Although the accused persons have entered appearance by filing Palakama, there is no option to regard service of notice on the informant of the victim. Accordingly, what is inclined to directly in view of the submissions made by the learned ADP, learned Additional Advocate General, what is inclined to hear the informant of the victim. Therefore, the registry shall issue notice to the informant of the victim to enter appearance in this TRP within brackets so moto 4 of 2023. It shall be indicated in the notice that in the event they are unable to appoint, they are unable to engage a lawyer of their own, they may make a request to the registry for appointment of a legal aid counsel. We propose that the notice be served on the informant of the victim to the officer in charge of the jurisdictional police station, i.e., Which police station? The Mokokchung PS within -2, Roman 2. The registry shall hand over the notice to the learned additional advocate general who would send it to the officer in charge of Mokokchung PS within bracket, sorry, dash Roman 2 for service on the victim, the informant. Next one. The officer in charge of Mokokchung PS-2 shall ensure that the notice is served before the next date fixed, and the service report be returned to the court through the office of the additional advocate general. Next one. The notice is made returnable on within how much time will serve? 2 weeks. Give a date, next date. Fifth is okay for you? Fifth is okay for you? So what is the stage of proceedings before Dimapur the district judge?
Charges has already been framed, my lord. CC has been conducted. Trial has been stayed. Trial has been stayed.
Trial has been stayed.
Yes, my lord.
Okay.
So even for the incidents of the accused as well.
That was with which order? Okay. The interim order passed. You just said the notice is made returnable on 5/4/2024. The order dated. No, the stay of the proceedings of GR case number 34 of 2023, which was passed by the learned single judge by order dated 2/11/2023, stands extended till the next date of listing. Next file is on 5/4/2023.
For motion, item number 1.
Sorry, on the CGC.
Lordship.
Who's appearing? You are appearing? Okay. But Mr. Jamil and counsel for the petitioner. Also, your name, I sorry. From the Government Advocate appearing for response number 1 and 2. And Mr. Yangaravati Leonard, CEC appearing for response number 3. Explanation notice on this. The petition criminal. This petitioner is the daughter.
No.
She is the daughter of the detainee.
Order of the detainee.
Removed by the daughter of the detainee. Was presently lodged in District Jail Dimapur. Against
Central
whom
Jail.
detention order dated 27/4/2023 has been passed under PT and DPS Act.
Lordship.
Which has been confirmed by order dated 13/7/2023 passed by the Chief Secretary to the Government of Nagaland Home Department. Detention of the petitioner has been extended by imperial order dated 18/10/2023 passed by the Chief Secretary to the Government of Nagaland, extending the period of detention till 26. No, they just say it's been extended the order dated 18/10/2023 as well as order dated 24/1/2024, thereby extending the period of detention till 26/4/2024. The name of the section is PIT NDPS Act of 1988. The notice is made returnable in 2 weeks. Because this what you call against the detention order, we can't give you such a long time. You have to do it urgently. It can't be taken up. This is it's a habeas corpus matter. You can't take it up like that. You must understand this is a preventive detention orders which make challenge. You can't give it time like that. Make this notice returnable on 1/4/2024. So requisite extra copies of the rate petition is served on the Government Advocate as well as CGC in course of the day. Based on 1/4/2024.
For orders, item number 3.
Instructions do appear on behalf of response number 6 and 7. Lordship.
Achha, just a moment. This 2 days back, I read somewhere this national highway matter. Is the Supreme Court in session of this matter? I was told that. Where I read, I don't remember. Some orders of this court was stayed by the Supreme Court.
Regarding this,
Construction of national highway. Please try to find out. You are aware of it? No.
No.
Who is appearing for national highways?
Also, my for NHIDC and Lordship, but Mort will be aware of the correct position, Lordship.
Who?
Mort. the Ministry of Road Transport, Lordship.
No, I understand, but there would be some lawyer for the appearing for the national highways matter.
We can take instructions, Lordship.
Can you find out? Can you
There
find
was a
out?
PIL pending, Lordship. Smooth of PIL, Lordship. 2019, Lordship.
I'm not aware of the years, but there, I just asked the master, he is aware of there are two PIL. One is
Lordship.
from Diyapur to Kohima
Lordship.
and other is from Kohima
Kohima to
onwards.
Mao, Lordship.
Yes,
Yes, Lordship. Kohima to
So-
Mao is pending before this honorable court. And
but this Dimapur
Dimapur
matter has
Kohima
been
to-
stayed by the Supreme Court.
Yes, Lordship.
This matter relates to which road?
Lordship, this matter to,
It falls in the parent district,
Parent
Lordship.
district.
Parent district.
Parent district.
Parent district.
Yes, different district.
This doesn't affect the,
Yes, Lordship. The subject matter is
No,
different.
no, it's
It'll be different.
Yes.
this 1, 6 and 7,
Yes,
you are appearing. Who's for respondent for 1?
Lordship, one, the two appeal.
I don't know this practice. Continuously, I am finding it.
Yes,
For Union of India, you are taking steps. Why don't you serve it to the CGC?
Lordship,
What is the
that
practice here?
is, Lordship, we tried serving a copy to
You-
them,
you-
but however, they say.
Because
that we
you are
need
ensuring that
instructions.
the process will be slow.
No,
Please,
no,
Lordship.
Lordship.
There is a number of cases against the board. Most probably around 11. And in all those cases, ministry, they are engaging private counsels.
No, you see, whatever the Union of India does, then you disband this CGC system altogether. You can't have a CGC who refuses to take notice because the ministry is engaging others. Then we'll issue notice on the law ministry. If they don't, if the CGC is not empowered to appear for the Union of India, no point having this system. You see, otherwise you produce a notification saying that the for Ministry of
Yes, Your Lordship.
MORT, you'll not be permitted to handle cases. Once you're a law officer of the Union of India, you can't say that they are engaging private lawyers, therefore we are not taking notice. We can't do that.
We have accepted notice, we have sent it to the ministry. But again, the ministry, they are waiting.
No, they may do whatever they want. But can the CGC or the government advocate refuse to take notice or any standing council refuse to take notice because the authorities are engaging private counsel? We can't approve that. Because then we can't take up any matters. You are preventing the court from proceeding.
In all the other ministries, the CGCs are taking up. But
No, then we'll put it in the order. We'll
I
record your.
I have also personally written to the.
No, it's okay. We'll record your submission, but in the order we'll say that we are compelling you to appear. Correct? Counsel for the petitioner State respondent numbers 2 to
Yes.
5. And, huh? Just 2 to 5. And council for respondent numbers 6 and 7 are present. Having noticed that respondent number 1 is the Union of India, represented by the Secretary, Ministry of Road Transport and Highways, comma, we found surprising that the petitioner had taken steps for service of notice on respondent number 1. Stop. Mr. Yangarwati Leonard, CEC is present in court, and therefore we had asked him as to whether he would accept notice on behalf of respondent number 1. Stop. On the query of the court, comma, the learned CGC has submitted that usually the Ministry of Road Transport and Highways, comma, Government of India, engages private counsel to represent their cases. Next paragraph. We do not approve. No, notwithstanding that the Government of India or their departments engage a private counsel,
In this
Comma.
particular ministry always.
comma, but once they appoint a central government standing council, comma, the learned CEC cannot refuse to accept notice for the Union of India. In the absence of any notification by the Ministry of Road Transport and Highways, comma, Government of India, to disengage standing CGC to appear for them. Full stop. Therefore, comma, we deprecate the practice followed by the Ministry of Road Transport and Highways, comma, Government of India, of not having confidence on the CGCs, for which the CGC is unable to accept notice. Full stop. Next part. Therefore, comma, we direct the learned CGC to accept notice on behalf of the respondent number 1. So requisite extra copies of the petition be served on the
Served in
learned
the course of
CGC in
the
course of the day. We grant 4 weeks time to the respondents to file affidavit in opposition. Next paragraph. Having taken note of the issues raised in this PIL, the respondents are directed to positively file their affidavit in opposition at least 2 days prior to the next date of listing. Next paragraph, list on 15/4/2024. Next paragraph. Just before that, you write. Before this, you write, the learned CGC shall send a downloaded copy of this order to the authorities of to the Secretary, Ministry of Road Transport and Highways, Government of India. List on so and so.
Bishop, memory we listed on Wednesday,
Pardon me?
on one Wednesday.
Wednesday, okay,
Yes, 15 is Monday.
okay. 17. 17-4. 17-4.
For hearing item numbers 4 and 5.
Worship, item number 4 and 5.
Just a minute. Just.
Sir, reference please. Well, remember single judge, by judgment and order dated 8/4/2022. order 8/4/2022 with a part of corrector. By this order, by this judgment and order, the Honorable Single Judge has differed with the judgment and order that passed by it. Passing or judgment and order that 8/6/2017, passed on civil revision number 6 of 2015. In the matter was referred before the.
In which volume we'll find that Administration of Justice in Ireland, that 1937 Act, which volume?
1937 rules.
Which volume? Rules. The original proceedings before the council court was under this act.
The issue involved in this case is as to whether the learned district and sitting judge can entertain an appeal under Rule 31 of the Rules for Administration of Justice and Police in Nagaland Act 2007 against the decision passed by the village
No,
authority.
that's why we are asking. In this case, the original trial which went before the village council court is a proceeding within the meaning of Rules of Administration of Justice and Police Nagaland, correct?
Yes, sir.
Okay.
The village authorities they are empowered under Rule 24.
First of all, please show us from this act the power of the village court to take up what you call this issues relating to commercial transactions or contracts.
In the case of the commercial contract.
Where is the power vested on the village courts to adjudicate the issues which they have taken up? Here, the issue which was taken up is the contract between the two parties,
Between the two parties.
which relates to payment adjustments and profit.
Payment of contract commissions. Yes.
So whether that jurisdiction is vested on the village authorities, that is the first thing we wanted to know. Because we'll tell you what is in our mind. Because if the village courts does have the jurisdiction, then the question of entertaining of the appeal will come. But if, to the contrary, if the courts do not have the jurisdiction to take up those issues, then the answer would be to delegate the parties to go to the approach the civil court. That is the what you call rough idea we have. So that's why we are putting you that question.
Yes, so
Yes, please.
To verify that, we need to go back to the initial.
Please come over this side. Yes, Mr.
In
Hyderabad.
order to see whether the village courts or the GBs have jurisdiction to entertain civil matters. Now, we need to go back to the 1937 original rules.
Yes.
Because this one is after amendment.
Okay.
And after amendment, that was in 1984. Under the definition,
Third amendment was in 1987.
yes. Now, A, B, especially A, these customary courts means and includes village courts, subordinate district customary courts, and district customary courts constituted under chapter 4A of the rules. Now, why we cannot apply this rule is that these rules under chapter 4A constituting the customary court has not yet been enforced. And therefore, we
Please,
need to go
please,
back to the
please,
audio text of the
please, please repeat again. I did not catch it. Please repeat again.
These courts,
Yes,
as defined in definition A,
yes,
this village court,
Yes.
customary court,
yes.
they have not yet been constituted. And although chapter 4A is already there in the rules,
Okay.
that is yet to be enforced. It
Oh.
is not yet enforced. It is still not applicable.
Oh,
That is the main problem here. And therefore, the reference court says that in view of these customary courts, now they are not subordinate to district and session judge.
Right.
That part.
yes.
Now, in order to see whether there is customary courts and whether the Mazudar, GBs, and other village authorities have the jurisdiction to entertain civil matters, we may refer to the 1937 rules.
Okay. Okay.
Yes. Should I proceed or let him complete?
Senior also will take this.
We leave it to your wisdom. We are not saying anything because if you want, you can start because you are a senior counsel. We will not mind hearing you first.
Because we are totally in support of the judgment rendered by His Lordship Sato and also by His Lordship L.S. Jamir. So according to that, now, and especially according to Justice Sato, where the subject matter of the dispute does not relate to any customary practices, then appeal will lie. Then we are supported. And for that, I would like to go to the National Court.
No, that was our prima facie idea also.
Volume 1.
That was our prima facie idea also.
Yes.
I think that it is this paragraph, this Civil Revision 6K of 2015.
Yes.
That is the judgment of Honorable Justice Sato.
Yes. Volume 1, page 159. In the blue book, blue cover book, it is at page 75. See? Rule 1 is general, but more particularly, I would like to go to Rule 53, Chapter 4, Civil Rules. In the blue book, it is page 85, Chapter 4, Civil Rule.
This one?
Yes.
Page?
Page 85.
Yes.
Mary Lordship. The administration of civil justice in the Naga Hills is entrusted to the Deputy Commissioner, his assistants, and within bracket, such tribal courts as may be constituted according to rules to be made by the Governor of Assam. close bracket, and the Mazadars, Gamburas, chiefs, headmen of Khels, and other village authorities. So this is the constitution, the first constitution of courts in Nagaland, the then Naga Hills district. And in this volume, in this Naga Hills Act of 1937, there is no customary law as such. I'm sorry, there is no customary courts as such. Nowhere it is defined in this, the original text. Then now 24, Mazadars, Gamburas, chiefs, headmen of Khels, or other village authorities sitting with the village elders in council are empowered to try without limit as to amount, but with the following reservations. A, they may not try suits in which a native of the plain or a native of another village not resident in their jurisdiction is a party. B, all suits to be decided in open darbar in the presence of the parties and at least 3 respectable witnesses. Then 24A is tribal courts may try and hear such cases, appeals as they may be empowered to try and hear by the deputy commissioner with the approval of the governor of Assam. Now this also is not enforced in Nagaland. There is no such a tribunal or customary courts. Then 26, Rule 26, all proceedings shall be by our host and the Mazadars, Ganguras, chiefs, headmen of Khels, or other duly recognized village authorities shall not be called upon to make either record or registry of their decision. After hearing both parties and their witness, if any, they shall pronounce a decision forthwith. Then Rule 35. Rule 35, the High Court and the courts of deputy commissioner and his assistants shall be guided by the spirit, but not be bound by the letter of the Code of Civil Procedure. So, these are the first constituted courts in Nagaland when it was under history. At that point of time, now there is no mention of any other separate courts like customary courts, nothing as such in the old days. And therefore, if we are to go by the definitions of civil court under section 3 of the CPC, now these courts, they exercise civil justice, matters dealing with civil disputes. So they are the original courts in civil matters as well. And these courts are the subordinate courts of the then ADC judicial or this deputy commissioner, assistant deputy commissioner, or additional deputy commissioner, whether judicial or from executive side. Now, therefore, since these courts designated such as Mazadars, Anguras, chiefs, headmen of health, there is no distinction has been made to try whether customary customary laws or other civil laws. By this, it shows that it can try both. Even other regular courts, now the invocation of invoking the traditional practices is not barred. At times, it is not barred. Although there is not a customary court, it is not barred to apply the principles of customary practices or traditions whenever it's called for. Therefore, these are the first courts whereby they have been empowered to deal with all types of civil matters. All types of civil matters. And it has been gone on till today. Now, the initial program has come up, and I'm sorry, before that, initially, in the definition, we have no ADC judicial or DC judicial or DC judicial. No, no separate court as such in the original text. Now that has been incorporated by the 1984 Amendment Act of the Rules. That is '95. Page 95. Page 95 under the chapter 1 general definitions. In these rules, unless the context otherwise requires, customary courts means and includes village courts, subordinate district customary courts, and district customary courts instituted under chapter 4A of this rules. B. Deputy commissioners in these rules, except where the contrary appears in the context, includes additional deputy commissioner, additional deputy commissioner as and when appointed, and also shall also include, it says also shall include officers designated as deputy commissioner judicial and additional deputy commissioner judicial as when appointed to administer criminal and civil justice under this rule. Now, by this amendment of 1987, customary courts have been introduced for the first time under chapter 4A of the rules. But till today, this chapter 4A has not been enforced, and this court has not been constituted except village court, which I'll come back to. The other courts, customary courts such as district, subordinate district customary courts, district customary courts, have not been constituted, nor chapter 4A enforced. And by definition, deputy commissioner and additional deputy commissioner includes deputy commissioner judicial and additional deputy commissioner judicial. Now,
Just a query. This amending act, which you have shown at page 96, customary courts.
yes,
Is it required under this amending act that this court is required to be constituted, or once this,
it is to be
amending act-
constituted. It is required to be constituted.
okay, where is the enabling provision for that?
Chapter 4A. would see chapter 4A, 103. Chapter 4A, customary courts.
103, yes.
Constitution of courts. First one is, there shall be 3 classes of customary courts as specified below in the state of Nagaland, to be constituted by the state government, of Nagaland, for the trial of suits and cases between parties, all of whom belong to a scheduled tribe or tribes with powers and jurisdiction mentioned in this chapter. One is village court. Two is subordinate district customary court. Three is district customary court. So the functions is village court. So now these are to be constituted by the state government. But it is not constituted, and the whole of this chapter 4A is also not enforced till date. And you will see when, by this amendment, when the nomenclature of additional deputy commissioner judicial and district judicial commissioner was incorporated in the rules. Now this is as steps for separation of the judicial from the executive. And this additional deputy commissioner judicial or district judicial, they are all trained persons, having legal background. They are all law graduates. They can be appointed only as a district judicial or district judicial, not otherwise. So this is the first step, perhaps, for the separation of the judiciary from the executive. Now, this is in 1984. Now, after this also, now these were brought the services of this ATC judicial or DC judicial or assistant deputy commissioners having the legal background. That was they were brought under the administration control of the Gauhati High Court by notification published in the Nagaland Gazette dated July 27, 1999. Your Lordship may see in my petition, civil revision number 6, year of 2021, at page 63. Page 63 of my petition, civil revision number 6, year of 2021, page 63. Now, as early as 1999, these officers were brought under the administrative control of the High Court. Not in 2008. There's a mistake in the book as well as in the judgment. They must have overlooked this one. May I read the Lordship?
Just a moment.
There are two petitions. Civil revision petition number 6, 2021.
Achha, yeah. Okay. 6. Okay.
Yes, 6.
Yes.
Page 63. This is extraordinary order July 27, 1999. in exercise of the powers conferred by Article 237 of the Constitution, the Governor of Nagaland is free to direct that the provisions of Article 223, 233, 234, 235, and 236 shall apply in relation to the judicial officers of the state appointed as Deputy Commissioner Judicial, Additional Deputy Commissioner Judicial, Judicial Magistrate First Class, and Judicial Magistrate Second Class with immediate effect. It is further ordered that the judicial officers of the state appointed as Deputy Commissioner Judicial, Additional Deputy Commissioner Judicial, Judicial Magistrate First Class, and Judicial Magistrate Second Class be placed under the administrative control of the Gauhati High Court of Assam, Nagaland, Manipur, Meghalaya, Tripura, Mizoram, and Arunachal Pradesh. So, although they were brought under the administrative control of the Gauhati High Court, now these APC judicials exercise all their powers under the rules. Then subsequently in 2006, now the judicial service rules was introduced. And
No, just a moment. In this chapter 4A, which you were showing us, chapter 4A, which you were showing us,
yes,
it also contains the provisions for appeal.
yes,
And for that, it says it should be a district customary court.
yes,
That you say has not been constituted.
no. Because by a subsequent notification, that has not been applied. Thank you.
The judicial service rules we have seen, it is in the first file. This is Nagaland Judicial Service Rules.
Yes.
It
The
is,
first one is
yes,
2006.
yes, 2006.
Yes,
And first amendment in 2009.
2008. By which nomenclature was changed. Now, till 2008, by notification dated 22/5/2008, in my petition, it is Letter D6. Page 66 of my petition. Now, by notification dated 22nd May 2008, the nomenclature was changed. In exercise of the powers conferred by Article 309 of the Constitution of India, read with clause 3 of Schedule A of the Nagaland Judicial Service Rules 2006, the Governor of Nagaland is pleased to change the nomenclature and redesignate the following existing judicial posts in the state. The existing nomenclature, one is DC Judicial, now changed to District and Session Judge. ADC Judicial to Additional District and Session Judge. 3. Judicial Magistrate First Class to Chief Judicial Magistrate and or Judicial Magistrate second class to Civil Judge Junior and to conduct both civil and criminal cases. Now, even after the constitution of this judicial service rules of 2006 or 2008, even after change of the nomenclature, now they exercise the powers under the rules. Although they have been brought under the administrative control of our High Court, Gauhati High Court, still they continue to exercise powers given under the rules. And my humble submission is that simply by changing the nomenclature of opposed, whether the powers given to that officer earlier or that designated post earlier would be posted automatically. It would not.
Apparently, it would not. Apparently, it would not. Because power, so far as jurisdiction to take up appeals or suits has to be vested.
Yes.
But there can't be presumption of power.
But if it does not host the jurisdiction of these courts, earlier designated as this is judicial or this is judicial, then there they continue to exercise the powers given under the rules for filing of suits, entering in appeals from village courts or for debashes, mazadars or from compras. So they continue. And in my lectures, I have given some as examples. Although they have been designated as such, they still continue to entertain the appeals. Then and
But,
they
but,
continue.
but please clarify.
Yes.
You see, what is intriguing us is that when chapter 4A, with so far as regard to that power of appeal is concerned, if that court has not been constituted, then how can there be an assumption of power? Because although you are telling us that there are precedents where the district and session judge or the judicial magistrate or the judicial magistrate second class are taking up adjudications as a customary.
No, not as customary court, because from the beginning, the application of the spirit of CPC applies.
Yes.
And in connection with customary practices, no such thing exists. There is no
Okay.
question of applying the spirit of CPC in customary cases or customary practices. No, totally different. So once we come under the rules for appeal or even for filing suit, now we follow the spirit of CPC. Almost in letters. But we cannot say in letters because the law says spirit applies. So we follow the spirit. And almost it is by way of letters. Even filing of a plane, we follow the provisions of the CPC, course of action, everything, illusion. Those are not provided under the rules then. Subsequently, by amendment, that was incorporated. But in the past, it was not there. But we follow that.
Okay.
And in many civil matters, when the matter comes from the lower levels, like Kamburas, Devashis, or village, now they don't follow the procedures. Even in cases like contract matters, they don't follow the provisions of the CPC. So in maximum cases, 99%, the courts try those cases in the war. One, it reaches the regular side courts like DCJ or DCJ or State Executive Commission. So there is no issues framed.
There's no issue, there's no requirement of record to be kept.
Yes. And no, there's no cross-examination. In some cases, witnesses may be examined by those court, but there was no cross-examination. So on the face value of those statements, the courts, the lower courts give the decision. So the authenticity of those witnesses' statements cannot be verified without cross-examination. So in 99% cases, those are tried de novo. And once we try de novo, we go by the CBC. Although it is not applied in letters, we go by the provisions of CBC. That is the practice. Now, subsequently, our Registrar General's case, now it has upset almost in many parts. And now we have been landed in a dilemma. Now, where to go and appeal? When there is no customary course, how do you file appeal? We have no problem with the application of CPC or CRPC or with the application of the CCA. But for the time being, where do we go? Where the litigants go? It is, in my opinion, it cannot be the intention of the judges in Registrar General case to deprive any person of availing the opportunity of being heard. And also, it cannot be the intention of that court. You see that one court applies the letters of CPC and another applies the spirit of CPC. Because it says.
There's a
customary
question
courts-
coming to the mind. You see, please have water. There's a question coming to the mind. You see, if the customary courts, as you said, was not constituted,
Yes.
then that is a lapse on part of the state not to constitute it.
Your Lordship, true.
Then second, there is a second part
Yes.
which says that when litigants approach the civil courts as and raise before it a customary trial, issue of customary trial, not being a civil suit, expressly civil suit, but it's a suit in the garb of a what you call customary trial. And when you move this court on that, now the question is that again for that purpose also, the under the judicial service rules, there must be a vesting of power to this courts to take up customary issues. You see, am I clear in communicating with you? You see, the first part is that the government has not created these courts, constituted these courts. Now there is a regular courts which are functioning.
Yes.
And there you say that they are also taking up customary cases.
No, not customary cases. Not customary cases.
Okay.
Because pure customary cases, I don't know what would be the pure customary cases, but.
No,
pure
we no,
customary cases, for
no,
example,
by customary court, what I am saying is that I'm referring to this court of this Congress, the Washis and all those matters
Yes.
where certain suits are being the act envisages rules 37 rules envisages that it can be taken up as a customary in the customary courts.
No, Your Lordship, no such expression is there in the provision, no word. And Your Lordship, in fact, in Nagaland, not a single institute has been designated as customary court.
That's what I am saying.
Yes.
If it
No.
is not there, then
It is not
then the regular courts which are taking up those issues, those will be completely without jurisdiction.
No, Your Lordship, because when these Mazadars, GBs, and village authorities, they are constituted, they are empowered to exercise civil jurisdiction, civil justice.
Yes.
Because the law did not say that these are customary courts. Or the law did not say that this will try customary cases or in terms of customary practices. No,
Okay.
it was not there.
Okay.
So these are subordinate civil courts. So when there are subordinate civil courts, then appeal will go up to district judge. That is my contention. Because they have not been designated by the state as customary courts.
Just. These authorities are Mozadar, Gaungura, Chief, Admin of Khel,
Subsequently, Dubashis have also been included by
Yes,
subsequent amendments.
kindly give me the names so that I may make a note. These are Mozadars.
These are Mazadars, Bamburas,
Just a moment. These Gaunguras, chiefs, headmen of Khel.
chiefs, headmen of Khels, and by subsequent amendment, the Bashis, or other village authorities. Perhaps this is village council or other village authorities.
Dobashi's spelling would be D-O-B-A-S-I-S-H.
Dobhashis.
Mozadas, Gaungura, chiefs, headmen of Khels, Dobashis.
Yes. And other village authorities.
You say that they are subordinate district customary courts.
No, not customary courts. They are subordinate courts to the other civil courts, like session judge. They are subordinate to district. These are civil courts, lower civil courts. Original having original jurisdiction.
Subordinate district
Any
courts.
matters.
Subordinate
Yes.
district courts.
Subordinate to district courts.
Subordinate to district courts.
Yes. Because they have not been designated as customary courts. And we cannot expand that one. We don't have it the force of law.
Please come to this provision again.
Which part?
No, the provision of this Mozadar Gaungura's taking up adjudication.
Yes. Under Rule 54.
Under Rule 24.
24, yes, 24. Read. Now your lordship will see in A, 24A. They may not try suits in which a native of the plains or native of another village not resident in their jurisdiction is a party. Means they can, if a plain person is in the village or another person from another village is in that resident of that village, they can try. And for this plains or another native, maybe from another tribe, if he is a resident of this village, now we cannot apply customary law.
Cannot try suits in which a native of plains or native of another village, not resident in their jurisdiction is a party.
Yes. So these are civil courts, lowest civil courts.
So if they are residents of that village, then they can take up.
They can
If,
take
if,
up.
if they are not natives of that village, they cannot take up.
They cannot.
Okay. We'll take a short break and come back.
One second, division will sit, no?
Just a moment. We were just having a short discussion on the matter. If we have understood you correctly, you are saying that the power of the Mozadar, Gaumburas, etc., are there to try civil suits.
Yes,
Then you say that because of the change in nomenclature,
yes,
this the only the nomenclature was changed, the jurisdiction was not taken away, and therefore the district courts, civil courts, would otherwise have the jurisdiction to try an appeal.
yes,
Correct.
yes,
But the two things are coming up. Number one, the state government has not notified formally.
no,
But the second is Article 371A,
yes,
which says that anything done should not affect the administrative, tribal courts or customary courts or the practices which are being followed. So there's an attempt to save all this by Article 371 capital A. Correct?
Your Worship, but 371A, that is not an enabling provision for the state to create customary laws or to constitute a customary law.
No, no, no.
It is only a protection.
No, that's not protection. That's what you are saying.
Yes.
Once there is a protection, therefore we can't interpret by saying that the Civil Courts Act, Bengal Agra Assam Civil Court as being enacted, would take away the power of appeal because of the change in nomenclature only. The 2008 notification you showed us is only change of nomenclature.
Yes,
So therefore the power of appeal otherwise has to be there.
yes, yes.
Correct?
Yes,
So in this context, we are trying to formulate the questions we are having.
yes.
Number one, whether you'll accept that this is a case where we'll have to issue a notice on the Advocate General because of the fact it requires interpretation of the 1937 rules
Yes,
vis-a-vis Bengal Agra Assam Civil Courts Act. Because what is happening is when the judicial officers are coming up, they are basically proceeding as a civil court
yes,
and not they are not accustomed to taking up appeals
yes,
under the 37 rules. Therefore, your argument is number one, that the Registrar General's case
yes,
basically gives supremacy to the civil courts, and therefore the adjudication under 37 rules is taking a backseat.
yes, yes, yes,
Not in your language, but so far we have
Yes,
understood this
yes.
is what the essence of your argument is.
yes.
So do you suggest that it would be appropriate to issue a notice from the Advocate General of the state for two things? Number one, to show us a way about how to assimilate the 1937 rules with the Civil Courts Act.
Yes,
That is one.
yes,
Second is, if the state government through the Advocate General appears, or his nominee, maybe additional Advocate General as per his choice,
yes,
if they appear, maybe the state government will pass appropriate orders to activate this customary courts, and those issues will no longer be alive.
yes,
The interpretation of, we also save in the process the adjudication
yes,
which has already taken place, which is the Registrar General's case.
yes,
And the state government, if it comes up with a notification, then the customary courts or the village adjudication procedure under the 37 rules, those are also saved.
yes,
And therefore, we put into motion the safeguards which are available under Article 371 capital A.
yes. No, in fact, your lordship, after the judgment,
Just.
Mr. Igalu,
yes,
now this chapter 4A has not been notified.
no,
What would have happened had it been notified?
means the government has to constitute the district customary court, subordinate district customary court.
Then where the appeal would go in,
District customary court. is the
then it will
highest
not go
under
to
the-
district judge.
No,
No.
no.
Then,
They can approach the high court under 227 or 226.
so notification of chapter 4A coming into effect of chapter 4A would solve the problem.
Partly it will solve. The present practical problem will not be solved.
By present practice, it will not solve.
It will not be solved. It will be totally different. There will be no question of even CPC, even the spirit of CPC. Now, your lordship, in fact, after the after the judgment of this registrar general, in fact, the state has made an attempt to bring out Civil Court Act. Now, a committee was constituted, headed by TBJP. He made thorough study, he made consultation with this and that, who knows. Then it was at the final stage. Then when it was about to submit that one, it was submitted, I heard, then somebody says this and that. So now again, we are back to zero. We have not understood the application of CPC. Many of our public, even some of our lawyers, I'll be frank, we have not understood the implication of 371A. At times, we thought that there is an enabling provision to make us frame rules under that. Many have got that impression. Oh, when somebody saw that.
But in places where there are this practices in force, for example, Arunachal Pradesh,
Yes,
there's a Assam Frontier Regulation of 1945.
yes.
But practical experience shows that notwithstanding that adjudicatory process, the high courts are still burdened with all those litigations again. The general impression, I'm not making a, I'm not making a specific statement, it's a general idea which we are getting. The general opinion we are forming after looking at so many cases which are piled up in the High Court is that the people are somehow losing faith in the old traditional system of adjudication. There may be many reasons, we are not on that, but the general impression we are gathering is that the people have started losing faith on those systems, and therefore they are reposing more faith on the normal civil court system. We may be horribly wrong, we don't know. But this is general impression we are gathering. So, if both of you permit us, then yes, Mr. Jamil.
May, that the customary courts in part 4 of this 37 rules is not been notified yet. So that is the admitted position. I admit it has not been notified. So from the village court, it was supposed to come to the
District courts.
subordinate district customary court, district customary courts. Hierarchy was there, but it has not been given it. But for our purpose, if the articulation being made by my learned senior friend is taken as a law, then all the judicial officers, the second as civil district judge, civil judge senior division, civil judge junior division, all will become subordinate to deputy commissioner. That is.
No, you see, that is
one
why,
problem.
that is, no, you see, that is why we are trying to have the Advocate General's opinion here. You see what is happening. You look,
Lordship, I'd like to place before your lordship a judgment which was laid by your lordship.
because in this second case, this.
No. Your lordship, this is.
No, I'll come to it,
2020
I'll come to it.
judgment.
In Civil Revision 6, come to page 66 of Mr. Iralu's matter. Please see page
No,
66.
Your lordship, appeal provision is given in 31 of the rules, as your lordship is aware. Now here, your lordship come to para 21, your lordship. It is in page 11. Of course, it is a different matter, but then 34 section rule 23 and 24 is interpreted here. May I read para 21, your lordship? Page 11, para 21.
Yes.
Para 21, your lordship. What can be understood is that the rule 23A is just a supervisory power invested among the DC and additional DC. It has existed and it is not referable to the matters of appeal. Para 22. And the next issue of reference is as to whether the office of ASC, Excise Assistant Commissioner, may be equated as assistant to DC. The provisions of Rule 1C reads, assistant to the Deputy Commissioner in this rule shall remain and include officers appointed as such to exercise powers assigned under the rules and shall also include officers designated as assistant to the Deputy Commissioner Judicial as and when appointed to administer civil, criminal and civil justice under this rule. The reading of the Rule 1C postulates that assistant to DC includes any officer appointed as such to exercise powers assigned under this rule. What can be understood is that officer other than DC or EDC, that is Additional Deputy Commissioner, can be appointed as assistant to DC. In the administrative hierarchy in the districts, after Deputy Commissioner and ADC Deputy Commissioner, the next officers in the line are Subdivisional Officer and Extra Assistant Commissioners. The expression, page 12, your lordship, the expression shall mean and include officers appointed as such under the rule 1C must be understood as officer below DC and ADC, which are referable to several STOs and ESs, who are also class 1 officers in the administrative setup. The only rider to this is that such officer must be declared as assistant to DC. There is no other visible interpretation of Rule 1C. We therefore hold that ESA can be declared as an assistant to DC under rules of 37. So if we go by this judgment, then the appeal against the village council to come to the assistant to Deputy Commissioner and the administrative officer, that is, not to the civil court.
That's why you see, that's why we are telling you, please come to page 66, which Mr. Iralu was referring to, of Civil Division 6. So you see, from this, we are trying to ask you two things. Number one,
Yes. Yes.
for the purpose of Nagaland Judicial Service,
Yes.
the three posts, Deputy Commissioner Judicial, ADC Judicial, District Magistrate First Class, Judicial Magistrate Second Class, have they changed nomenclature. Correct? Now, for all other administrative purposes, have you disbanded the post of the DC Judicial, ADC Judicial, Judicial Magistrate First Class under the Deputy Commissioner? Have you disbanded that?
Now that
Have you abolished those posts?
their nomenclature has been changed.
No.
Their nomenclature has been changed and those officers.
No,
judicial
you see,
officers are put under the control of the high.
no. You see, if you have understood Mr. Iralu correctly, 37 rules are there.
Yes, yes.
1937 rules are there.
And this- yes.
So in that rule, there must be some adjudicatory mechanism. Correct?
Correct. Appeal is
Now,
there.
for the purposes of Nagaland Judicial Service, you change the nomenclature.
Right.
What happens to the adjudicatory process insofar as 37 rules are concerned?
It is there, appellate is there in section rule 31, your lordship. Provision is there, rule 31, your lordship, can see in the small logo. Rule 31, your lordship. May I read your lordship? An appeal shall lie from the decision of the Mausada, Kongora, chief, hitman of kills, tabashis, or other duly recognized village authority.
You're reading which page?
Page 34.
This is page 34, your lordship.
34. Yes.
Rule 31. Page 34, rule 31. An appeal shall lie from the decision of the Mauzadar, Kongura, chief, headman of queues, tabashis, or other duly recognized village authority to the tribal court whenever that's written on otherwise. That means part 4, tribal courts means part 4 a customary court to the deputy commissioner or his assistant. A record shall be made of the matter and dispute and the decision of the various authorities. If necessary, the court shall examine the parties and if the decision appears to be just, shall affirm and enforce it as its own. If the court sees reason to doubt the justice of the decision, it will try the case as de novo or refer to a panchayat as a law. So, duly recognized village
But
authority.
what is this page 38 then? New rule 31. What is this?
In my page, it is.
No, please,
34.
look, please come to page 38. There's a new rule 31.
Worship, this page 38, that is addition to worship. Addition to the main provision. Which is there in page 34.
No, it says new rule. That means substitution. When the words are used, new rule 31, new rule would mean substitution of the earlier. So first of all, there must be a provision of an appeal. Then the procedure will come, the deputy commissioner after hearing the parties. So where is the provision for appeal now? That we'll find at page 37, new rule 29. But now you see there is a what you call curtailment. It says an appeal shall lie to the deputy commissioner against the decision of any of his assistants.
That is in regard to the decision of the deputy commissioner.
So what happens to this? If you have substituted 31, where is the appeal? Appeal itself is no longer there. Because 31 old at page 34 says appeal shall lie from a decision. Now, under the after the amendments, where is the provision of an appeal lies?
Your Lordship, our case is said relates to the decision of the village council. We have to prove for appeal.
That's why we are asking. You
31
see,
is very clear. 31 is very clear.
No,
It has to
31,
do
you
the
see-
Deputy commissioner and its assistants.
no, I have no personal knowledge, but when I'm reading a book, at page 38, I find that it has been substituted. Now, is it your case that 31 after even substitution will remain? We don't know that.
Your Lordship, 31 is still there. And then page 37
No, it
And
can't be.
38
The two things
are-
can't remain.
are new additions, are new additions. 31 remains. Otherwise, it was not omitted, Your Lordship. 31 is not omitted. Otherwise, it could have been reflected.
You see, come to notes at page 34, by section 18 of Nagaland Act or 87, it is provided that rule 31 be deleted. I am reading page 34. That's why I was searching for a new rule. Page 34, down below notes. By section 18 of the Nagaland Act of 1987, it is provided that 31 be deleted. However, as explained in reference to rule 22, corrigendum was issued so-and-so to the effect that notification dated so-and-so, respectively so-and-so, shall be deemed to have been inserted after the words chapter 4A and 8 and 14. So-and-so, it says. Now, therefore,
Now, therefore, as a matter of legal application, the provision of the Rule 31 have been retained in the original form.
now you see, you omit all this, come to page 36. The same note size is continuing. Now, first paragraph says, second paragraph, the scope of rule 31 of the rules also came to examine the case of so-and-so. In this case, a division bench of the Honorable High Court had held that the de novo proceeding under rule 31 will be an original proceeding. For the purposes and must be treated as such, and further held that entrustment of a case to assistant or DC for de novo trial was valid. Therefore, you see, what Mr. Irado was saying that once an appeal goes, the ADC tries it de novo, taking fresh evidence, taking everything without taking cognizance of the proceedings which was there before the Gauhati, before the Dovashis. So therefore, it is because of this interpretation of Rule 31. Then you say, incidentally, the court also examined the scope of Rule 34 in answering the question as to once having resorted to Rule 34 by way of appeal or revision, before debating further appeal or revision to the High Court will lie. The court took a view that the party already appealed under 34. The remedy by way of revision or first part of the rule to High Court will still be available. But if the party directly approaches the High Court either in appeal or revision under the rule, no further remedy will be available in the High Court. This decision honorable took so and so. So therefore, you see, there is already an adjudication. But thereafter, we see this Rule 31 amended. The Deputy Commissioner, after hearing the parties to an appeal, and this insertion of Rule 30 and new Rule 31 is inserted as new provision by Section 22 of the Nagaland Act, 1 of 87, which is at page 138. 38, there is a footnote. Because if you go by the first adjudication, which is provided here, 1987, 1 GLR 156, then we don't have to answer anything. But then we only say that it's an original proceeding and it may continue. We reiterate what is there, already there. We don't say anything in this case. But when Mr. Ralu is making a submission that perhaps with this sort of adjudication and non-enforcement of Chapter 4A, those consequences are the only things which prompted us to issue a notice on the Advocate General for better implementation. Otherwise, if we go by 1987, then we don't have to adjudicate anything. We merely say that the issues before us has already been answered. But what happens to the protection which Article 371 is trying to give to the state? You can think over, I am not in a hurry. In fact, this issue has quite a lot of ramifications.
Yes.
So, not even not in court, but in your bar also, you three can meet and then have a discussion as to what should be the better way for the court to proceed. Because you three are, in this case, you all are not in adversarial litigation. I will not say this is an adversarial litigation. Our party is before us, no doubt, there is a division. But still with the issue raised, it cannot be said to be an adversarial litigation.
Your Lordship, so far as the 71 years concerned, it is not an enabling provision, but a protective provision.
That's what we are saying.
It's about four provisions.
So what happens to that protection? You see, there is a act, but empowerment is given to the under the Civil Courts Act. Judicial officers whom we are training, when we are posting it as a judicial officers, we don't train them on the on this 1937 rules. So actually, we find the force in Mr. Irazu's submission when he says that when normal courts are taking up the matters, it's the entire application of CPC. The question of spirit is not there. The original idea of 1937 Act, the rules, those give way to the civil courts. Please think of how these issues will affect people of Nagaland. We already have an answer in 1987, 1 GLR, 156. I would seriously think that you can deliberate amongst yourselves and then try to address us. Because primacy, our idea was that we have the Advocate General been issued a notice so that these issues can be thrashed out and all these judgments can be read together. Maybe perhaps we can have a larger bench recommended for taking up the issues. If we have an intention to save 1937 rules. No, that's okay, but we are interpreting only that whether here only the issue of interpretation was whether they are subordinate to ADC. We said no. No, observations are there, but that's why we are saying a larger bench. I have used the word. The issues are if we find that these are issues which has to be adjudication for a proper to give a proper mechanism for the 1937 Act, then we proceed. But if the bar you are at unison that no, we can just decide this issue and then go away with it. We can do also that. Try to have a discussion. This is not an adversarial litigation. When you discuss in the bar, it will not be as if what you call we are compromising with the what you call the sanctity of the court proceedings. Not since it is not an adversarial proceeding for this issue. You can deliberate and you can tell us. You can fix it on day after tomorrow. Please think of, we are not compelling you to do it. It's your own choice. Because in the bar, you can have assistance of others who may be more, what you call, conversant with this practice under the 1937 rules. Maybe you will get a good ideas to address us. You wanted to say something?
Yes,
Please.
Lordship, considering the diverse opinion of the court as well as the people who are the bar. Finally, the bar has made a suggestion that to come up with the Civil Courts Act, Nagaland Civil Courts Act, that will solve all these problems. For
No,
that
no, it will
reason,
not. It will not. I have some
Courts Act-
reservations because you see, once you are trying to save 1937 rules, then there will be what you call there are two parallel litigation process.
Yes, Lordship.
One is under the 37 rules
Yes, Lordship.
and one under the Civil Courts Act.
Yes, Lordship.
Under Civil Courts Act, we have an empowerment under the Bengal Agra Assam, which I am more acquainted, is that jurisdictions are vested for the purpose of taking up adjudications.
Nice.
But in 1937 rules, you don't have vested jurisdiction. You say that it can take up all civil suits.
Yes, Lordship.
And the reservations are, as Mr. Idaro read, that only two things, A and B.
Yes, so far the appeal is concerned, Lordship.
Yes.
Appeal against any decisions of the Mozadas, Gamburas, and all this, in order to tackle all these issues, that once the Civil Courts Act that comes into, and also when it comes into, and also that as Lordship has rightly pointed out, the enforcement of Chapter 4A, that was also had a discussions that was placed before the government, and in fact, Council TB Jamir was here to explain to the positions of how and the stage where the Civil Courts Act is lying right now with the government. For quite some time, even this case has been keep pending, and till today has been pending, that thinking that the Civil Courts Act will come into play and that will be enforced very soon. But since right now the matter has gone back.
Just a moment. I'm just interrupting you for a moment. You see, this Civil Courts Act, even if it comes,
yes,
it will not have any effect on the adjudicatory mechanism under 37 rules. It can't. Because when there is a Civil Courts Act coming in, prima facie, the idea is for the CPC to have an overwhelming effect. Because in the adjudicatory process under the Civil Courts Act, nowhere in the country, because the first rules of this kind is Assam, Bengal, Agra, and Civil Courts Act. There, the issues of, because the purpose was to bring about clarity in the procedure. So once we give clarity to the procedure, then CPC comes in. There's no other alternative way.
True.
If CPC comes in, then along with that, you have also the enforcement of the principles of Evidence Act.
Yes.
But then you see, we have a protection of laws for the customary practices under Article 371.
Yes.
We are not expecting a person in a village to be acquainted with the procedural laws.
Yes.
But if you give primacy to Civil Courts Act, let us assume that tomorrow it is coming. If you give primacy to the Civil Courts Act, then the customary practice of having an adjudicative process through a Gauhati, how will that happen if the Gauhati is not trained in law? If he is to accept procedural, consider the procedural aspect and evidence, principles of Evidence Act, then he can't be a person trained in without training in law. Therefore, I was interrupting you only for that reason, because I don't see that with coming of the Civil Courts Act, you can have a parallel mechanism for 1937 effective implementation of 37 rules. I may be horribly wrong. The state wisdom may be larger to encompass that also.
Lordship,
But I don't think so.
No, Lordship, that is right. So far, the idea of taking care of the customary side, that the Chapter 4A, that which is yet to come into force, that will take place in the meantime, so that the customary, that appeal towards the customary matters, that will go in that line.
For that, that's why I said,
Yes,
to
Lord
cut
Chair.
it everything short, I said that unless the Advocate General appears,
True, Lord Chair.
because
This is-
it can't happen. The state government can only function after the advice of the law officer of the state.
Lord Chair, Lord Chair.
Because if chapter 4 is to be implemented,
Yes, Lord Chair.
it will be two things. Number one, will of the bar. Why will of the bar? Because it will directly affect legal practice. Because one part, we are making it very clear that there is a parallel adjudicatory process and people may opt for traditional adjudication. So there will be a apprehension in the bar, maybe perhaps some amount of litigation will be lost from the bar. That is one. That is why I say will of the bar. Second is will of the people. Whether they want a parallel adjudicatory process, which is as per their customary laws. Although, Mr. Yadav said that it is not nomenclatured as customary courts or village courts, but still we have a village appellate authority under chapter 4A. It will be the appellate authority which will be constituted. So we have to empower the customary courts also of village heads. That is why we are a bit apprehensive of how to proceed.
Yes. I agree.
So may I fix it day after tomorrow, so that in the meantime you can have a deliberation amongst yourselves, and so that we can formulate how to proceed. Yes, you wanted to say something?
Lord Chief, in this regard, I just would like to clarify one thing. See, in Nagaland, we have two parallel system of functioning courts. And one is the customary courts meant by the executive, which we are talking about, this DC, ATC, and other village authorities having jurisdiction as provided under the provisions of the rules 1937. That is one, followed by the procedure laid down by the said rules. And the other courts are general courts created by the virtue of Civil Courts Act 1887, CRPC and CBC, meant by the members of the judicial service under Nagaland Judicial Service Act 2006. Now here, very much.
No, sorry, we are unable to follow your first part of the argument.
Yes.
You see, let me tell you.
Yes, my lord.
If we have understood Mr. Iralu correctly, then he says that customary courts,
Yes, customary courts, my lord.
which is not formally constituted under chapter 4A, because chapter 4A itself is not there.
No, your honor, it is constituted. Every village have a village court.
No. Please see, chapter 4A is not, has not been implemented. There's no notification of implementation. We have been told that there's no gazette notification for implementation of chapter 4. Therefore, although there are village authorities, but there are Gaumburas, but they are not formally called a customary court. Village authorities are there, we have no doubt about it. They are there. So their empowerment, that is why we said first part we are unable to accept, because of the fact that even you see, Mr. Goyanchan is also saying the same thing. But once it is not implemented, then you see that is the issue before us. We've told you, our minds are very clear. Number one, we have shown from this book only that 1987 judgment is there. So it's a shortcut for us. We merely don't answer anything and say that this already been interpreted and therefore end of the matter. But practicality of it, whether saying that would solve all the problems we are having.
So Lordship, as Lordship has suggested, let the Advocate General, he also appeared in this case.
No, you take a decision, we'll take it up day after tomorrow.
No, Lordship, whether that will be convenient for Advocate General because.
No. We are permitting you to have a discussion among yourselves and other members of the bar and try to formulate so that we can pass an appropriate order on that day. Correct?
Okay.
So,
Okay, yes.
because from your deliberations, we'll have only one reference to be made. Because then we are avoiding our decision-making process right now. We'll be depending on your wisdom to have a question formulated and whether it would be appropriate for us to issue a notice on the Advocate General. So, and then the issues of reference. Number one, enforcement of this chapter 4A, then the constitution of the customary courts by appropriate notification, and then streamlining a parallel adjudicatory process. Correct. So please formulate those questions for us. Because you are in the field, you know these laws more better than us. So we are not claiming that we know these laws better than you. So please try to formulate a point of reference so that we can pass order accordingly. Correct?
Yes.
Okay. All sides, including Mr. Iralo, Senior Counsel, Mr. R. Iralo, Senior Counsel, present. Expertise agreed to by both sides. List on. It is 13th. 13th, 2024. There's one more issue. In these cases, there is a what you call the parties are before us.
Yes.
Can we also envisage a way where we can give relief to these petitioners and still keep this question open for an appropriate decision? Because you see, there is an adjudication. A party has approached the court.
Yes.
He's got an order now. This is a question of appeal. So while we are deliberating on the larger issues, can you also suggest how to give immediate relief to these people so that they can, without that being formulated, they can still have a clear-cut adjudicatory process being taken up, and then
in both the cases, it is to proceed with the appeal. So the question, I doubt whether they can be separated at the
no,
moment.
I'm just posing that query.
Yes.
You can still deliberate
Yes,
whether by keeping this issue open,
yes.
can we still have this matter led to a quietus?
Because in the reference order, now that was out of his case, in which
Correct.
the court says that this appeal was filed before the district judge at Dimapur. And because of that, now he cannot proceed also. In my case, revision 06/2021. Now my case is that it was before the Gauhati Lochama. The matter was decided. We filed an appeal before the Assistant Civil Judge Senior Division. And that Senior Division Judge says that I cannot entertain this one. You go to Village Council Court, where under Village Council Act, there is no such court. So against that, we have come.
No, that's why We're just posing that query. You can deliberate on that also, because whether we can still keep this issue open and then settle this matter, we can try to be quietest to these issues of the petitioner.
Okay, we'll think of.
I think there's one more matter in the DB. I think that will be rolled over. There's one more matter left out because we have single bench to attend. And two will be sitting singly.
Lordships, then can this matter be taken up tomorrow because the person has been under custody for 3 years?
Just say pass over the day. We'll come tomorrow.
I'm obliged, Your Lordships.
Because the register to
Obliged, Your Lordships.
Convincing power busy as they, Mr. Shaggy.
Please, Your Lordship. May I be pleased to mention item number 14, Your Lordship. 1-4. Your Lordship, I'm giving my journal slip also, Your Lordship. Here, Your Lordship, we have already filed an affidavit, Your Lordship. And when the matter come up last time, Your Lordship, we had an intensive hearing. While taking an hearing, like the court deems that we need to file an additional affidavit. So in that
You're-
regard, Your
You
Lordship.
informed the other side?
3 weeks, yes, Your
Ah,
Lordship. I would inform.
Both sides are represented. On the prayer made by Learned Committed with matters to adjourned today, list after 3 weeks.
Yes, Your Lordship. Lordship, I also like to mention item number 22 to 38, Your Lordship.
You're taking consent?
Yes, Your Lordship.
Okay, same order for
Your
22 to
Lordship,
38.
here,
Yes,
in
Mrs.
fact,
Amir.
on the last occasion, last chance was given. Last chance was given starting since October last year, and the last order is 13 to 2024, Your Lordship. Not 2 weeks, I say let them take 3 weeks, but failing which matter be heard.
Just show me that.
3
Item
weeks, Your
22.
Lordship.
Huh? Item 22.
Lordship may kindly see order dated 13 to the last order. Even, in fact, chance was given since October last year. So if they want 3 weeks, let them take 4 weeks. But
Okay, Your Lordship, the 4 weeks may granted, we will
no,
definitely
no,
have
no.
to
Don't
file
go
an
like that.
affidavit. Your Lordship,
Please.
it's analogous and like we're accumulating the documents, Your Lordship, that is the
No, make
problem.
it 3 weeks, but do it. Otherwise, we'll proceed with the matter on the basis of materials available on court. He's good, but he may not be good after that.
Your Lordship may be gracious, Your Lordship.
Okay. Both sides are represented. On the prayer made by the committed, okay? List after 3 weeks. Having noticed that, next paragraph, having noticed that one opportunity was granted by order dated 13 to 2024, we make it clear that if the counter affidavit is not filed within the time allowed, attempt would be made to hear the matter on the basis of materials available on record.
3 weeks, Your Lordship.
3 weeks. You want a date? You want a fixed date?
8th of April. More than 8th of April, 8/4.
List from 8/4/2024.
Obliged, Lordship.
Yes, there are other
Much
requests
obliged.
of item 44 and 45. Who's there? You've taken consent? You've taken consent, okay. Item 44 and separate orders for item 45 to 53. What size are represented?
Lordship.
Pyramid well and committed advocate list after 2 weeks.
Lordship, it's maybe 3 weeks, after 3 weeks.
3 weeks. Okay, 3 weeks. 3 weeks are item
44 to 45, 50.
45 to 53. Okay, in 45 to 53, 3 weeks. In item 44, 2 weeks.
Your Lordship. Your Lordship, the 44 to 53, Your Lordship, it's the same matter, so.
Oh, same
maybe
matter.
after
Okay, then 3 weeks.
weeks.
3 weeks. Okay.
Much obliged, Your Lordship.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 19. Your Lordship, I've
19.
received the affidavit in opposition this morning.
19, we are not adjourning. You have not given an advance information.
And I'm yet to file my reply, Your
Your
Lordship.
Lordship, I filed the affidavit this morning, Your Lordship, and copy was served to her, Your Lordship. This morning, Your Lordship.
The copy was served today.
Yes, Your Lordship. Today only I could file, Your Lordship, this morning.
Okay, both sides are represented.
So kindly grant me 3 weeks time
The
to file
counsel
my
for the
reply.
petitioner submits that she has received a copy of affidavit in opposition filed by the state. Seeks time to take instructions and to file reply if so advised. Matter stands adjourned today, just after
3 weeks.
3 weeks.
Lordship, I'm for respondent number 5, and I've also filed my affidavit in opposition, Lordship.
You have filed?
Yes, Lordship.
Okay, as per counsel for respondent number 5 submits that he has also filed the affidavit in opposition in the matter.
Obliged, Lordship.
Much obliged.
The blessed Lordship.
Yes,
Lordship, I beg to mention item 15.
15.
Yes.
I'll have to refuse adjournments.
Lordship, in this case, I may bring for respondent of 5 to 9. Lordship, in this case, pleadings are completed. And I've received a reply file by the petitioner. You may have read that this may be listed for hearing an usual course.
No, we'll take up hearing. Readings are complete, we'll take it
Okay,
up.
Lordship,
No,
I
because you
have some
see,
personal difficulties.
no, if you're not filing an advance memo, you'll be taking up hearing, there will be no adjournments.
Lordship, I received a written reply on 8.
No, you see, on the 8th you have received.
Yes.
Achha, okay. Both sides are represented. On the fair made by and council for respondent number 5. Matter stands adjourned today. List after.
Usual
No,
course, Lordship.
no, we're not making usual course.
Next week, Lordship.
See, the matter is otherwise ready for hearing. List for hearing. In the week commencing 1/4/2024. Week commencing 1/4. 1st of April, week commencing.
Lordship, if there's an interim, that may be continued.
Okay, interim order passed today, stands extended till the next day for listing.
Okay.
For motion, item number 59.
May I please, Your Lordship?
Yes. Yes.
My lord, this IA is filed for extension of period, my lord. Your Lordship, may kindly see the last order, my lord. Page number 20.
Where's the which order you want an extension?
IA, my lord. Page number 20, my lord.
No, we can't extend the orders of IA. You will have to
Yes.
ask for extension of the main order.
By this order, another 3 months was given to the state. So I can, within that spirit, the state could not consider the case of the petitioner. So I need.
No, this will be misconceived.
Yes, my lord.
You have been already granted an extension for 3 months.
Yes, my lord.
Correct.
Yes.
If you need an extension, you have to pray for extension of time in the original case, not in the IA.
So since, my lord, since it is continuity, so.
No, you can't seek extension of the orders passed in IA. IA has been disposed of.
Yes.
You want time to comply with the main order.
Yes, my lord.
You have to make a prayer for that. Have you got the point which I am
Yes,
trying to
my
tell?
lord. I got it.
IA is only for extension.
Yes.
Earlier time was granted, extended.
Yes.
Matter ends there.
Yeah.
There can't be an extension of extension. You withdraw this and file a fresh one.
Yes. Okay, my lord.
Correct.
Yes, ma'am.
Both sides are represented by this. What is the statement you have made here?
My lord, may I please, lordship, I have mentioned here that extension for that original from the original order, my lord. And for reference only, I have enclosed only that IA order. My lord. Original order, I have not enclosed. My lord.
You see,
In my prayer, I have mentioned that, my lord.
you see, there is an order of the court.
Yes.
In paragraph 2, you are saying that all this will take some lengthy process. It could not be considered. You say that the petitioners, along with some other situated work charge employees, have been forwarded to MRC. That means, are they above the orders passed by the High Court? What will this committee do?
Pardon, my lord.
Paragraph 2 at page 4.
Yes.
You have stated that you have sent these cases to MRC, Manpower Regionalization Clearance. Now, is this an authority above the High Court judgment?
No, my lord.
Then?
My lord, it is the proceedings which we have stated, because from there, from Manpower Regionalization to, it will forwarded to cabinet for approval.
Now, assuming this Manpower Regionalization refuses to do so, then what happens?
It will again forwarded to cabinet for approval.
No, you are going on a premise that they will do it.
Yes.
Supposing they refuse to do it, then what?
Well, they are eligible. They are eligible because the department is the eligible employees. Those who are eligible employees, they have already forwarded from finance to manpower regionalization, and from there again it will go up to cabinet approval. They are eligible.
Heard Mr.
E.T. Performed.
K.T. performed and counsel for the applicants, and Miss and counsel for the respondent. No, there's again a defect. Even if I want to do it, they can't. How many respondents are there? There are 20 respondents.
Yes.
And you are saving ink and page. In the cost title, you are not given those names.
Yes. Only the
Why?
men responding.
You are yourself saying that there are 19 others. Is their name not required?
And my lord, in that case, I may be allowed to withdraw this petition, my lord. With the liberty to file a fresh one.
Okay. Constate that this application is incomplete. So therefore, the non-counsel for the applicant. Applicants seek leave of the court to withdraw this application and to approach again. Stop prayer is allowed. Matter since closed on withdrawal with liberty to approach the court again. Okay. Next item is also same.
Yes, my lord, here there is only one respondent, my lord.
There's only one.
Yes. My lord, by this,
formed and counsel for the applicant. And Mr. L. Likha. Learned counsel for the opposite party. Next, by this application, the applicants are seeking extension of time 6 months extension of time. Sorry, make it further 6 months extension of time for compliance of the order of this court dated 21/2/2023, passed in WBC
Notice, my lord. My lord.
104 of 2022.
My apology. Here, my lord. This is the second IA that the respondent has filed for seeking extension of time. So another 6 months.
You see, we can't do anything. Even if you file contempt, even if you go ahead, they will still say that the procedures are in place. Supposing today this is not an IA we are taking up, we are taking up a contempt. What would happen here? They will show us that they are taking steps, their finance clearance is required. They are asking for extension of time. And it is not only one case. So many cases are there. We can't help it. At times we'll have to be lenient towards the government. They are not saying no. They are saying that the procedure will take some time. We'll allow that. We'll record your objection. Next, the Honorable Counsel for the opposite party has objections to the said prayer. First, next, consider the objection raised by the Honorable Counsel for the opposite party in view of the reasons assigned in this application that there are certain procedures required to be followed, after which the matter would be placed before the cabinet for approval. Court is inclined to grant further 6 months time to the opposite parties, sorry, to the applicants to do whatever is necessary within the time allowed, so that before expiry of the extended time, the order of this court dated 21/2/2023, passed in WBC 104 of 2022, is complied with in letter and spirit and without fail. Inferiority application stands allowed to the extent as indicated above.
Much obliged.
No, that is withdrawn. This is disposed.
For admission, item number 1.
No, please, Your Lordship.
Yes.
Your Lordship, I received the reply just now, Your Lordship, to my affidavit in opposition, Your Lordship.
What is the impediment in granting death cum retirement benefit? What is the impediment in grant of death cum retirement benefit?
Your Lordship, actually, we are of the condition that the petitioner retired, Your Lordship, but before that was implemented, Your Lordship, the gratuity, which was enhanced to 20 lakhs.
Yes.
I mean, yeah, that was implemented only after the petitioner actually, Your Lordship.
So it
retired
does not
from
get a
service.
retrospective
It was
effect.
not implemented at that point of time when the petitioner.
This morning, Lordship.
Yes, I.
Now, as per the reply, I have enclosed a chart of the payment which I was receiving, Lordship. Now, I retired in the month of March 2018. For the 3 months, I have been granted fees, scale of pay in terms of the 2007 ROP.
That is with ROP. This is gratuity, Your Lordship.
And if the ROP, the scales applied to the case, the other benefits are rising on the same ROP stocks we apply to. Rules 15 of the rules.
Your Lordship,
Just one minute. how we made this calculation of 20 lakh rupees? So this 17 lakh, you made a calculation. How we made that calculation?
Lordship, I have to say it by 11 of my.
Now, what was your service condition under the board? Under the board, what is the applicable death cum retirement
Your Lordship,
gratuity?
the applicable amount was 10 lakhs, Your Lordship, at the time when the petitioner was retiring, Your Lordship. And
where is
therefore,
that?
we gave that.
Where is
one.
that rules?
In
Where
my
is that rules?
affidavit in opposition, Your Lordship.
Page,
And that is also being admitted by.
page. What is the date of your retirement?
Date of retirement is
March, 31st March 2018.
31 March.
the amount received, Your Lordship, 10 lakhs, Your Lordship. That is in the writ petition, Your Lordship, page 31. Annexure D, Your Lordship. Writ petition, page 31, Annexure D, Your Lordship.
Just a moment.
His retirement, we will get it by page 11.
No, but then you won't get it. You're an employee of this
Autonomous
town
body.
and autonomous body.
Yes, Your Lordship.
The Payment of Gratuity Act for the government employees will not be applicable to you.
Yes.
Lordship, in a similar case, I have also stated, Lordship, and I have produced a report. In a similar situated case, an employee who retired, Lordship, he was also granted pay gratuity of 20 lakhs, Lordship, 20 lakhs.
Your Lordship, that was implemented, Your Lordship, because.
Just a moment, just a moment. Where is that? Where is the document?
Paragraph 12, Lordship, I have made a technical statement, Lordship. Paragraph 12, page 7.
When did this Mr. A.K. Dubey, he retired? What is the date?
I do not get the date at the time of filing the petition. But he was very much an employee of this same authority, Lordship.
Your Lordship, he
No, no,
retired
he
on
maybe-
31/7/2019.
Please don't interject for every statement he's making. I'm asking questions.
My apology, Lordship.
Just wait for some time. You see, is the date of is this date after after 20 August 2018? Was the retirement had taken place of this A.K. Dubey after 20 August 2018?
One day, Lordship, to get the proper instruction, Lordship. As to the retirement of Mr. A.K. Dubey, Lordship. The date of retirement. Notification clearly says, Lordship, this will come into effect from 1st January 2018, Lordship. Notification is very clear. Rule 1, clause B, clearly says that it will come into effect from 1st January 2018.
Which page you are referring to?
Page 12, Lordship.
12 of your writ petition?
Of the petition, Lordship. Annexure B, Lordship. Page 12. Number 1.
Oh, no. Don't show us this. Page 12 doesn't take us anywhere. This is for government employees, not for employees of this, what do you call? DAN. What is DAN? Development Authority Nagaland.
Lordship. I was paid scale of pay in terms of this ROP, Lordship. I've also filed a reply, Lordship, this morning. I've enclosed the statement of my salary.
Would it make you a government employee?
Lordship.
Would it make you a government of Nagaland employee? Even if you are getting the same scale. Now let us see if we give an example. I'm good in giving horrible examples. This is one of the horrible examples. You see, a salary of a judge is equivalent to a particular scale of the government of India. Correct?
Lordship.
So, do I transform myself from a constitutional authority to an employee of the government of India? Same scale. You get the point?
Yes, Lordship.
So, horrible example had to be given. Okay, fix it on Thursday. We fix it on Thursday then?
Your Lordship, otherwise I have make a statement in my affidavit that he retired Dubai.
He has to get a chance.
Yeah, no problem.
Correct. Both sides are represented. On the prayer made by the counsel for the petitioner, matter stands adjourned today based on 14.
For admission, item number 2.
Please, Your Lordship.
Yes.
I'm standing on behalf of my senior counsel. Here, our affidavit is ready, but we have sent to.
This adjournment will not be granted.
Lordship, we
I
have
made
sent
my-
obtained
I made myself
signature
clear.
from the
Unless-
client.
unless you give a advance information, no adjournment. This adjournment business is
My
going too far.
apologies, Lordship, but
This adjournment business is going too far. You're making me unemployed in the
Lordship,
process.
the petitioners are from other district. They're from remote areas, so
No, you could have given us advanced information. You see, you know that matters will be listed. That's why I made it very clear on the last occasion.
yes,
The
Lordship.
adjournment business must stop.
Lordship, my apologies, but kindly grant me 1 week time.
No, you look at my position. Disposal on day 1, 0, day 2, 0, day 3, 0, day 4, 0, day 5, 0. Correct. Today is again 6th day. Disposal rate is 0.
Lordship, last
That
chance
means,
may be given.
that means if you tomorrow get my roster and my disposal register, you will be the first women laughing. And look at this judge. For 6 days he's here, 0. Doesn't want to work. He's come to spend time. Correct. That's what you will say. Supposing you are not attending the court today, you are not aware of how many adjournments have been granted. From outside, what will you think of me? Correct. Think of my position. And people are accusing judges of not working. Is it not? What does media say? You've seen the Hindi movie, Tariq Pe Tariq. You've seen that?
No, Lordship.
No. Then think of us and look at that movie. What was that? Sunny Deol. But then you have to pay some cost to the government. How much?
No, Lordship, my apologies, but last chance may be given, Lordship.
Okay. But let me make a request to the bar. Adjournments, unless you circulate earlier, I'll be too harsh in these few days. Okay, both sides are represented on the prayer made by Learned Counsel for the petition. The matter stands adjourned today. List after 10 days.
Okay, Lordship. Much obliged. Much obliged.
For admission, item number 3.
Please, Your Lordship. Your Lordship, the petitioners are part-time instructors who were appointed in the Department of School Education. This is under the centrally sponsored scheme SSA, which is now merged as Samagra Shiksha. They were appointed by the.
Just a moment.
Yes, Lordship.
Which page is your infill letter of 29th May 2019?
29/5/2019.
This is page 60.
Page 60, yes, Lordship.
Yes.
It appears my lord has already read the file.
No, I'm not.
Now, Your Lordship, this is the second round of litigation. In the first round of litigation, our first batch of writ petitions were for release of salary, number 1. Number 2, for continuance of a service because the scheme is continuing. Then your lordship, as your lordship has rightly pointed out at page 60, this particular letter was placed before this honorable court. That provision has not been made to meet the salaries of the part-time instructors PTIs in the project appraisal board outlay. Hence, it is reiterated that no further extension beyond 36/2018 will be considered. On the basis of this letter, both in letter and in spirit, this honorable court was also convinced that fund has stopped pertaining to meeting the salaries of the part-time instructors.
Because it's a continuation in page 63 again of the same thing.
My lord.
It's a continuation in page 63 of the same thing again. Page 63.
Lordship.
Isn't
Yes,
it
Lordship.
the same effect that there will be no extension of the scheme beyond 30 June 2018.
So, your lordship, as I was saying, if my lord may kindly consider the.
And then you see this High Court order.
Yes, lordship.
This is at page, operative part is at page 165 onwards.
Yes, lordship. So this letter convinced both the court as well as the present petitioners that the fund provision has been stopped. That is why this honorable court will see at page 68, that is the operative portion of the first judgment, which order which my lord has already pointed out. Page 68, page 68, that is the operative portion, 68.
Yes.
The last paragraph, my lord. Yeah, but may I take your lordship to paragraph 2 also?
Yes, yes.
The petitioners who were engaged as part-time employees in different capacities in the office of the Directorate of School Education, Government of Nagaland, for a period of 6 months, which was subsequently extended on a fixed pay of rupees 10,000 per month, have approached this court by filing this writ petition seeking a direction from this court to quash and set aside a notice dated 26/6/2019 issued by the Directorate of School Education, Nagaland, White, number such and such, by which notice the petitioners, who were all part-time instructors under SSA, were denied extension of their engagement as a part-time employee.
Just a
beyond-
moment,
Yes,
just a moment. I'll just request you to just pause for a moment.
my lord. Your lordship.
This specific relief act, section
Section
14,
14.
clause D. Because it appears from your this part of the order that you are a contractual employee.
Yes, lordship.
So if 14 clause D,
Yes.
if it's a contract otherwise determinable in nature, then
Yes,
there can be no specific performance ordered.
In as much as the employees under the CSS, the centrally sponsored schemes, are concerned, my lord is aware that the appointment itself is coterminous with the
scheme.
Now, later on, after approaching the honorable court, seeking extension of service and for payment of the salaries for the duties already performed, letter was produced before the honorable court that no fund provision is there. Now, after approaching the honorable court, again the petitioners they filed an RTI application where it was seen that as part of the package, there are different categories of employees and teachers, your lordship, under the SSA, which is now Samagra Shiksha. It was found out that our salary component is also part of the entire categories of employees who are under the CSS scheme, Lordship. So when the other categories are allowed to continue, then how can we be the only categories who have been kicked out, Lordship, in a pick and choose manner, Lordship? That is why we have come back before the Honorable Court for consideration.
You see, let me put you a question in this manner.
Lordship.
You see, a government employee in Nagaland will retire at this age of 80, 60 or 35 years of service. Correct? But at times government extends service by 1 year or for some time for few people. So extension provision for extension is there. Is it not? Or can somebody come and say that my constitutional right under 14 and 16 is violated because I have not been considered for extension and somebody else was extended?
Well, Lordship, my Lord, I believe I understand what your Lord is coming to. However, in this case, which is under the CSS, Lordship, for the same category, they may be holding different posts, but in the same category, all under the CSS. In a pick and choose manner, some are allowed to continue, whereas the part-time instructors have been kicked out. And if our salary component is not part of the project approval outlay or the board, then your Lordship, we cannot be aggrieved. But our salary component is also part of the. Yes, Lordship. My Lord. May I take a Lordship to the RTI reply?
Yes, yes. Is it 168?
Yes, your Lordship.
Which part?
May I read your
Yes, yes.
Lordship? This is the letter dated 10 July 2019. Subject minutes of the meeting of the Project Approval Board PAB held on 7th May 2019 to consider the annual work plan and budget AW and B 2019-20 of Samagra Shiksha for the state of Nagaland. The meeting of Project Approval Board for considering the annual work plan and budget AWP and B 2019-20 under Samagra Shiksha for the state of Nagaland was held on 7th May 2019. Then Lordship, the relevant page may take a Lordship to page 216. My Lords, 216.
I'm only having the advantage because earlier some of my brothers had read this brief.
My Lord.
So he had taken the trouble of flagging all the relevant pages.
Your Lordship.
So the earlier effort is helping me.
Now, my Lord, we'll see the sanction post.
Yes.
By state under Samagra Shiksha under SS 3,464. The same total is continuing till last year, Lordship, the document which I could access, your Lordship. Till last year, the same total number is continuing.
3464.
3464.
Yes.
That is under the Samagra Shiksha, SS.
Yes.
Now, your Lordship may kindly come to the second table. The second table. Upper primary teachers contractual elementary. Can your Lordship see? In the second column.
Yes.
Upper primary teacher contractual elementary.
Yes.
Then art education, part-time instructors. Health and physical education, part-time instructors. Any other part-time instructors. So two, as my Lord sees the numbers, 211, 211, 211. The total coming to 633.
Yes.
633. Now, your Lordship, after apprising this court that our fund provision to meet our salary is no more continued, it has been discontinued. And this Honorable Court has also been misled to believe that the fund provision to meet our salary has already been discontinued. Now, the Nagaland Education Mission Society has come up with the statement that the overall fund, the amount of fund that has been approved by the Project Approval Board has not been received. In any case, your Lordship, if our component is already struck out, it's taken out from the consideration of the project approval board, then we have no case, Your Lordship. We have no locus standi to approach this Honorable Court. But our salary component has been continuously the same, has been continuing till last year, Lordship. To my knowledge, till last year,
Just let me understand.
my lord.
You see, let us say that there is a school. The
Lordship.
school has one headmaster, two teachers and two peon. Correct? So 5 people are there. So even under a different scheme, if this school is to be manned, they will have 5 people only. Maybe under a different scheme, but this school will have 5 people only. This school is not discontinued. Therefore, even for few years, this same school will be functioning, same school will be having 5 staff pattern. Now, for the first part, when you are under SS category, there was some sort of recruitment. Now, if that is coterminous with the scheme, now under the new scheme which is functional, this staff were appointed in which manner? I'm giving an example of 5 schools. If I teacher with a 5 staff category. In your case, try to explain it to me with this example so that it's easier for me to understand. 211 will have, say, 10 schools. Now we are giving an example so to simplify things so that I can understand it in simplified manner. The new teachers or employees who have been in this school, they were appointed in which manner? They must have got some appointment. And it is not your case that this salary is being paid to ghosts. Ghosts, I'm using a word because the ghost staff is also an acknowledged pattern. It's a term used by judicial pronouncements. Ghost appointments. That means there are fictional appointments where salaries are taken by the officer. Half of the money is siphoned off and half of the money is paid to the staff. So we call it in a legal term, ghost staff. So this new salary which is coming, component is coming in for 211 people. If we
633 people.
So if we convert it into 5 of my example, is it your case that out of 5 people, they are not working and this money is being siphoned off, or there are 5 people in that school, but in a separate engagement?
Now, Your Lordship, since if my Lord comes to my prayer, my Lord will get the point very clearly.
Yes.
Page 30, the prayer. May I read, Your Lordship? May I read, my Lord?
Yes.
Page 30, prayer A. Caution set aside a letter number such and such dated Kohima the 29th May 2019, Annexure 27, falsely declaring or claiming that salary for PTI has not been made by the project appraisal or approval board outlay. B. Caution set aside a notice dated the 26th June 2019 denying extension of service to the petitioners.
So now who are these 633 people?
They are the present petitioners, Lordship.
No. The staff pattern is 633, right? Again.
Your Lordship.
Under the new scheme also, the staff pattern has 633 staff.
Yes, included in the approved by the project approval board, Lordship. Our salary component has been approved.
No, not
So, Your Lordship,
salary.
the question
Not
is
your
whether
salary, not your salary. Salary component of 633 people. It may be you, it may not be you.
no, it is PTI is only us, Lordship. That is why I was pointing out to Your Lordship only my category. If not, there are many other categories, Lordship. And for the part-time instructors, the salary component is 5 crores 31 lakhs in a year. As my lord comes, if my lord comes to page 216, my lord will see clearly.
So are you saying that under the new scheme, no staff has been appointed?
Yes, lordship. So it is not even a new scheme as such, it has been renamed, lordship. And it's not only the category of part-time instructors, all those under the SSA, they have been merged with the new term, Samagra Shiksha, lordship.
Where is that? Where is that?
Your lordship, that will be in the affidavit of the state respondents also, lordship. Now, my lord will see that there are many other categories of teacher under this. I was just trying to point out to your lordship the part-time instructors, which is also part of the overall approved categories of employees by the project approval board. So the total salary is, my lord, at page 216.
Yes.
The second column, if my lord comes to the bottom, grand total of salary of teachers.
7193.
Yes, 71 crores 93 lakhs, out of which the amount to meet the salary of the part-time instructors is in the middle, my lord can see, 531.72.
Yes.
That is 5 crores 31 lakhs. So when our salary component is also approved and is part of the overall approved for the employees by the project approval board, how are we being singled out by misleading this honorable court, saying that the fund provision to meet our salary has already been discontinued?
Okay.
All the other categories are still continuing because the scheme is still continuing, my lord. So, your lordship, how has that money that has been released by the government of India, how has it been utilized? That utilization part is not explained in any of the affidavits of the respondents, your lordship. And whether the state respondents or the Nagaland Education Mission Society, whether they have the authority to divert the fund for usage for other purposes. That is why, your lordship, in my prayer, I have asked for constituting an inquiry committee to inquire into the mismanagement, diversion, or misappropriation of the salary of the petitioners.
You see, your answer is here in this same scheme you are referring to.
My lord.
Come to page 209.
209. Lordship.
Now, from here, this class of schools are indicated.
Which paragraph, your lordship?
You see, 10 is first is Kasturba Gandhi, then so and so forth, it goes on. And your categories is at page 215, serial number 13, support for salary of teachers.
Support for salary of teachers at
Yes.
13, elementary.
So here they are saying an amount of so-and-so was estimated as support of so-and-so, including 633 contractual teachers. State was advised to relook at the requirement of teacher headmaster post and rationalize deployment of teachers at all teachers are the responsibility of state.
Yes.
Correct. So it doesn't say the central will won't bear that. It says is the responsibility of the state. There is no dual cadre of teachers. Only financial support for additional teacher category would be provided under so and so. The additional terms of so and so. So this was late and it was said that this component would be of the state.
Your Lordship.
So now they're
If
saying
my
that,
lord reads it carefully, I may be wrong, Your Lordship, but my understanding tells me otherwise, Your Lordship.
please,
State was advised to relook at the requirement of the teacher/headmaster post and rationalize deployment of teachers, as all teachers are the responsibility of the state. It doesn't mention about specifically the 633 contractual
correct.
instructors.
There's
which
no
is our
dual
category,
cadre.
Your Lordship.
There's no dual cadre. Therefore, they are saying part-time instructors has to go.
Your Lordship.
Next line is, there is no dual cadre of teachers.
Only financial support for additional teachers' salary would be provided under the Samagra Shiksha. Any additionality as per terms and condition for recruitment of the teachers in the state is to be borne by the state. So, Your Lordship, any additionality, no, additionality is, in my understanding, Your Lordship, additionality is something which is outside this column, Lordship. We're part of those categories whose salary component is to be met, Your Lordship. So additionality would be outside this column, in my understanding, Your Lordship.
We don't know, we'll ask. For Samagra Shiksha is appearing. You're there?
Lord, I'm appearing for respondent number 3.
No, he's
And-
not yet completed. I've just stopped him to understand this. What do you call this? Page 216. That interpretation of 216. This check is not yet over. I've just.
Yes, Lord.
Only this interpretation of page 216, an amount of so and so.
Yes. Lordship, with regard to that, kindly come to paragraph 8 of our affidavit of respondent number.
So this is only a query of the court. You can later also you can tell us, Mr. Jamil. Later also you can tell us. This is the query which we'll have to respond to. Mr. Eki, you can continue and complete your part. Then we'll come to him.
Yes, Your Lordship. So, Your Lordship, it is my humble submission that if in this column, if we are to be taken as additionality outside this, then if we are in all these categories, the other categories mentioned are in, if we are out, all of us are out together, Lordship. Conveniently, the state has been trying to sideline us. Unfortunate for them that we are also part of the same category, where we are the only category that has been pick and choose and kicked out, Lordship. So, Your Lordship, even though the petition is quite fat, the argument is basically this.
Okay.
All those appointed in the same category as us, Lordship, the 633 contractual instructors/teachers. We are the only one who has been kicked out. So, Lordship, that pick and choose manner in which, by misleading this honorable court to state that the fund provision has already been discontinued, whether that holds water in the eye of law, and whether by kicking us out in a pick and choose manner, whether that is correct, legally sound or not, that is the issue, Your Lordship. And my Lord, as far as the fund is concerned, whether the total amount that has been sanctioned is received or not, we cannot just be the only category that has been in a pick and choose manner be kicked out. So, Your Lordship, whether the state has the authority, whether the state respondents or the Nagaland Education Mission Society for that matter, whether they have the right, under what authority have they misused or misappropriated or diverted the fund, Lordship? That also requires some inquiry so that the clear picture can be brought before the Honorable Court. If not, the petitioners in the first round of litigation ask for extension of service and for payment of the salaries which were yet to be paid. Lordship, a misleading document was placed before this court to state that fund provision has already been discontinued in respect to the part-time instructors. Later on, we applied for RTI and the RTI document says otherwise, Lordship. I do not know about 2024, but till last year, the fund provision was covering the categories of the part-time instructors also, Lordship. And the same total number of teachers is shown, Lordship. If fund provision for the 33 part-time instructors were discontinued, Lordship, then the total number of 3,464 would also be minused by 633, and the fund provision also would have been minused by 5 crores 31 lakhs 72,000, Your Lordship. But the same is still continuing. So, Your Lordship, reiterating in my petition, the prayer portion, Lordship, that is to quash and set aside the letter dated 29 May 2019.
Okay, again, this provision of section 14 would haunt you.
My Lord.
You see, if it's a contractual employment, at best, even if you are the employment is severed, you'll only get a severance compensation which should be as per your contract. You see, extension of a contractual employee. This is
Your
something
Lordship.
which is otherwise hit by 14 clause D. How do you overcome that?
No, Your Lordship, the question is fairness. First point, misleading the Zolmo Court in the earlier proceeding that the fund provision has been discontinued. If my Lord may kindly appreciate, that point itself also deserves the notice and intervention of the Zolmo Court, because the Zolmo Court was misled to believe that the fund provision has been discontinued. And that is why the Zolmo Court in its order, which my Lord has already seen, my Lord will see that at page 68, may I take a Lordship to page 68. This is the first order. (19/9, 2019), Your Lordship.
Yes.
May I read, Your Lordship? It has been noticed from the appointment orders of the petitioners that the petitioners were engaged only as part-time employees at a fixed monthly emolument. If the state respondents have denied the petitioners in further extension of their employment as part-time engagement beyond 30/6/2018 void the impugned notice dated 26/6/2019 as referred to herein above due to financial constraints. This is very specific, Your Lordship, because of the letter dated 29th May 2019, Your Lordship. This court, in exercise of power under Article 226 of the Constitution of India, cannot trust upon the respondent authorities to engage the petitioners as part-time employees for any further period, inasmuch as the engagement of the petitioners as part-time employees does not confer any legally enforceable rights to the petitioners to be further continued as part-time employees with the respondent authorities. If that particular letter was not there and the fund is continuing, Lordship, my Lord can surmise the matter and arrive to a conclusion that a direction would definitely have been issued on why a particular category, when the same other category of employees are still continuing, why we should be kicked out in a pick and choose manner, so long as the CSS scheme, the scheme is continuing, Your Lordship. But here, because of the document placed before this Honorable Court, to show that there is no more fund provision. That is why this Honorable Court took the view that if the state is financial constraint, then this Honorable Court under Article 226 cannot direct the state respondents to allow us to continue, given the fact that our employment is part-time in nature.
To that argument, there's a reply at paragraph 4 of their affidavit.
Lordship. Paragraph 4 of which affidavit, Your Lordship?
That's point number 3.
This one. Yes, Your Lordship. This I have read, that is why, Your Lordship, whether the amount is lesser or more. Your Lordship, whether throwing us out in a pick and choose manner when our same category of employees are continuing and still including us before the project approval board, Your Lordship. And our fund provision as mentioned as 5 crores 31 lakhs and 72,000. Is it not misleading, Your Lordship, whether it is fair or not?
But this is something which we don't have any arms to or teeth to monitor. You come to page, the reply to your query is at paragraph 8 of the same affidavit.
Your Lordship, this amount and the affidavit filed by the union, the Ministry of Human Resource Development, Department of Education, the amount is also, it doesn't tell you, Lordship. The amount projected in the affidavit filed by the respondent number 3 and the union's affidavit, Lordship. The total amount doesn't tell you, my lord. So at least for the sake of fairness, Your Lordship, on how the fund has been utilized, that also needs to be seen, Lordship, on whether the public fund, even assuming that our rights are not considered, at least there should be fairness in the system, Your Lordship. May I take your Lordship to my affidavit in reply to the affidavit filed by the respondent number 3?
Just a moment.
Lordship.
You are unable to accept.
Lordship.
Your argument we are unable to accept. You
No.
come to the affidavit of respondent number 5. Please come to paragraph page 9, Roman 15.
Your Lordship. The union has played very safe here, Lordship.
No. The last paragraph is very important.
Now,
It
my lord, may
says,
kindly come to 10
as
also,
per
Your Lordship.
Samagra Shiksha framework,
Yes, Lordship.
teachers are recruited as per terms and conditions of the respective states and union territories. Thus, the salary and service conditions of part-time instructors fall within the domain of the state government. As simple as that.
Your Lordship, the amount projected.
No, amount may be, you see, we
Yes,
are not
Lordship.
on the amount, right now we are on the fundamentals. If the union government also says same thing,
How will my lord consider this aspect where in a pick and choose manner, one category, one set of employees have been kicked out, but the same category of other employees are allowed to continue. And the fund provision for the kicked out category is also still continuing, but in order not to pay the kicked out category, coming before the zone court with misleading document to prove to show that fund provision for that category is discontinued.
you see what happened was, I'm giving an example when I was in your side.
Your Lordship.
The income was fluctuating, correct?
Lordship.
We had what you call fixed amount of people to be taken care of in the family. Now, let us say in a given week, my professional earning was less. Then what did I do? For a lawyer, every day is not a sweet day. So, in one particular week, if I had a less income, what would I do? I would cut some pockets here and there.
Understood, Your Lordship. But chucking out the entire 633, assuming that we are not part of those, the category of employees for whom the money has been sanctioned, assuming that half is received, why chuck out all the 633, Your Lordship?
Let us see what Mr. Zamir says now. That's all I believe. That's all.
Yes, basically that is the issue, Your Lordship.
Yes.
But I wanted to project this aspect to Your Lordship on how the amount there is a variation of amount where the union says we have released this much. The state said we received this much. There is a contradiction also, Your Lordship. But the union will also submit. I hope they have not just filed one affidavit. I hope they will point out to Your Lordship both the affidavits they have filed.
Yes.
May I please, Your Lordship? As the learned counsel for the petitioner has fairly submitted that this is the second round of litigation. In the earlier litigation, the petitioner has made the submission, categorical submission, which is a part of the record in this writ petition, that they do not, earlier writ petition was, they were terminated from the service with effect from 30th June 2018. But then they have been continuing in the work, performing their duties. Therefore, a writ petition was filed, and incidentally, the order was issued with the retrospective date. That was in 2019, it was issued. Therefore, they approached this honorable court seeking a direction to the mission to pay the salary for the period for which they have worked. And in that proceeding, they have categorically admitted that the petitioners do not have any grievance except the pending salary.
Where is that?
Lordship, may kindly come to page 165 of the writ petition. This is your document. 165. The order starts from 154, but relevant portion rest are cost title. So let me go to page 165. Here, the counsel was my learned friend Joshua Shiki. Kindly come to the third paragraph, which is the last paragraph towards the middle of the page. If your Lordship is at page 165.
Yes.
May I read, Lordship? The paragraph starts with, it is also. it is also submitted by the learned counsel that the petitioners have no longer any grievance other than the non-payment of their salaries between 30/6/2018 till the date the notification stated above was issued, that is 26/6/2019. Notification terminating their service was issued only on 26/6/2019. Therefore, till this notification is issued, they have been working. Therefore, they approached this honorable court claiming for their salary, and in that proceeding, they have categorically stated that they do not have any other grievance except the salary. So that was made by this honorable court. Last paragraph, page 166. In view of the submissions of both the learned counsels and in view of the fact that the order dated 26/6/2019 was issued by giving retrospective effect, the respondents are directed to pay the salary of the petitioners for the period between 30/6/2018 to 26/6/2019 if on verification they are found to have worked during the same period. So the direction was issued to make the payment of salary if it is found that they have been working. So the reason for referring to this document is, Lordship, the petitioners have admitted that they have no longer other grievance except for payment of salary up to 26/6/2019. Now, in view of this order, the petitioners are not entitled for any relief and they are barred by two principles of law. One is they are stopped to raise any other point because in that proceeding they have made a categorical stand that they do not have any other grievance except for payment of salary. Therefore, they are stopped to raise in view of this submission. That is one. Another principle, Lordship is well aware. The principle of res judicata is very much applicable in this case. They have adjudicated on this matter, same party, same issue, on the same point. Now, the principle of res judicata will come into play.
I don't think res judicata will come in. Maybe constructive res judicata, if you say explanation 4 of section 11, maybe that would apply. Res judicata would not apply. Res judicata is the, if issue is heard and decided.
Issue is decided.
So it may be.
Because, Lordship,
It may be explanation 4 to section 11.
Now kindly come to the prayer portion. What the petitioners are seeking for. What is their prayer? The terms and conditions of their engagement is for a period of 6 months. However, their services were extended beyond 6 months. And when the flow of fund was falling short, some activities are required to be cut down. Lordship has correctly pointed out about the family budget. That is what it has happened in this particular case also. And the mission, the Nagaland Education Mission Society, as per the guidelines of the MHRT, NIMS has to work as per the guideline issued by the MHRT. So, some activities we are required to give more focus, more attention. Some activities, they may direct us, no, you cut down. Earlier, when they were engaged, the petitioners were under SSA, Samakra Shiksha Abhiyan. But then subsequently, it was amalgamated. RMSA and SSA has been, sorry, amalgamated, and the conglomeration of this is called Samakra Shiksha. That is done for the purpose of restructuring and revamp to focus more in all-round development of education. Lordship. It has got two sections, elementary section and a pre-primary section. That is up to class 8. Pre-primary section is up to class 8 and elementary section is from class 9 to 12. So it has got two sections, elementary and pre-primary sections. Petitioners are appointed as part-time instructor for a period of 6 months only. Prior to the amalgamation of SSA and RMSA. And their services have been continued by an order dated 29/5/2019 due to fund constraint. Lordship will find the discontinuation order in the page 61 of the writ petition also, but I'm not referring since my learned friend has already referred to. Now, the fund of the NIMS, Nagaland Education Mission Society, is received from MHRT. The fund is received from MHRT and the approval of fund.
What is your body called? Nagaland?
Nagaland Education Mission Society, in short, NIMS.
Yes.
The fund received by the mission is approved by the PAB, Project Appraisal Board. They will make the proposal and if that is approved, it will be remitted back to the society, that is NIMS. Sometimes
funds are approved by
Project Appraisal Board, and in certain contexts, it is also used as Project Approval Board. Am I right? Yes. Sometimes the fund received by the NIMS is less than what is projected by the PAP, Project Appraisal Board. If it is less, we have to curtail the activities. And in the process, some employees will be compelled to discontinue. And the fund received by the NIMS is utilized on the basis of priority. And how to prioritize the priorities, the discretion is left with the NIMS. However, that will be done as per the instructions and guidelines of the MHRT. We cannot do it on our own. Some discretion has been left with the NIMS also. Some to minimize some projects, some schemes. And that can be done on the basis of the priorities and the guidelines issued by the MHRT. Now kindly come to the prayer portion. What they are praying for by filing this writ petition before this honorable court. What is their prayer?
Before that,
Whether those prayers can be considered by this honorable court or not.
No, before that, Mr. Sikhi has also referred to his time and again saying that in the previous round of litigation, you had misled the court by giving a wrong document. He is referring to perhaps page 61, although it's not shown that. Perhaps it is page 61. The part-time instructors.
Yes.
They said that he says by now referring to this this compilation. Now he says that financial outlay was all along there. But you have misled this board by giving this as if this part was discontinued.
We have explained in detail in our affidavit, but assuming that some funds are misused or misutilized, for example, whether this honorable court in exercise of its power under Article 226 shall and can go into all this disputed question of facts and calculating the factors, how much they have spent, how much, whether this is tally or not. I believe that will not be possible. Number one. Secondly, if at all there is any misappropriation, let the petitioner come with the clear instructions and documents and evidence that, look, this money has been sanctioned by this sanction order, and this money, this much money has been spent here, misused here, and like that. Nothing. Just plainly making an allocation, well allocation.
Petitioner would not be, petitioner cannot do it. Because you see, these funds are managed by the government.
Yes.
The National, what you call Nagaland Education Society.
Lordship.
NIMS.
Yes.
They will not permit him to inspect the books of accounts. So therefore, he can't say on affidavit. He can make only what a citizen can do is to point out before the court that there is a document showing that the funds are allocated. And if we have been out, then where does this money go? So make an inquiry.
Yes. Now, can we come to paragraph 4 and 5 of our affidavit? How the composition of the Samagra Shiksha, paragraph 4 and 5. Here, what is the role and how it is consisted? Paragraph 4 of page 4 of affidavit of respondent number 3. Page 4, paragraph 3. Before that, Lordship, it will be necessary to start from paragraph 3, composition. It talks about the composition, how it is consisting, and what is the role of the Chief Secretary, and what is the prayer of the petitioner. Paragraph 3, Lordship, may I read that prior to 2008 to 2019, the present Samagra Shiksha was functioning under Sarva Shiksha Abhiyan, SSA, Rashtriya Madhyamik Shiksha Abhiyan, RMSA, and teacher education. In view of shortage of policy, in view of the change of policy of the government of India, these three schemes were merged together under the nomenclature of Samagra Shiksha. Under the Samagra Shiksha, there are elementary sections starting from class pre-primary to class 8, and secondary sections starting from class 9 to 12. Under the elementary section, there are categories of teachers such as graduate teacher science, graduate teacher maths, graduate teacher English, and primary teachers. The major components of funds are utilized for salaries of the teachers. The present petitioners are under elementary section who were engaged under SSA, which was done prior to the merger of SSA and RMSA. They were engaged as part-time instructor on contract basis with the terms and conditions inter alia that the engagement is initially for a period of 6 months, subject to further extension, and this engagement was purely for a time period and liable to be terminated without prior notice and does not confer any right for regularization of service. The petitioners were engaged by the Department of School Education, and the discontinuation was also done by the order dated 29/5/2019, issued by the Director of School Education due to fund constraints for payment of their salaries. Paragraph 4. That the role of NIMS is to implement the schemes under Samagra Shiksha within the parameters and the guidelines issued by the ministry. The fund for the scheme is received by the names from the ministry and the same is utilized for implementation of various activities all over the state. The fund for the names is approved in the project approval board and the sanction is released to the mission. However, in most cases, the fund relates to the names is much lesser than the fund approved by the PAP, and as such, in most cases, the fund received by the names is lesser than the fund projected in the PAP. Keeping in view of the budget allocation, the fund is utilized on priority basis by identifying the schemes and projects in terms of the directives and guidelines given by the ministry. 5. That the petitioners were engaged as part-time instructors only on contractual basis for a limited period of time, which may be extended depending upon the funds received from the ministry. The funds received from the ministry were not commensurate so as to pay the salaries of the petitioners, since the fund released were much lesser than the budget approved in the PAB. And as such, due to fund constraint, the services of the petitioners were discontinued. This is the reason why they were discontinued. In the present case, the petitioners have projected their case in such a manner that although the ministry has released the fund for payment of salaries for the PTIs, but the same was not paid to them, which is absolutely misconceived. This may be taken note of seriously, Lord. Because all along they have been singing that the funds have been released, but it was not paid to us. That was the contention of the petitioners. It is pertinent to state herein that in the process of identifying the priorities based on the availability of funds, the authorities were constrained to minimize certain projects, schemes, and to focus on certain priority sectors. Therefore, the services of the petitioners were discontinued, which is consequential to the terms and conditions stipulated in their engagement orders, and as such, no legal rights of the petitioners have been violated in the present case so as to invoke the indulgence of this honorable court under Article 226 of the Constitution of India. Now, I would like to show a chart how the Samagra Shiksha is constituted. This will just show, Lordship, the composition. The relevance, there is some relevancy here. Samagra Shiksha, governing party is the organ. Ex-officio chairman is the chief minister, is the head. Vice president is the minister of school education. Executive committee, they can make important policy decision-making body. Normally 2 to 3 meetings every year. And chairman, this is important, Lordship. Chief secretary is the head, and he is the chairman of the names, Lordship. And the vice president is commissioner and secretary, school education. Thereafter, in the next page, Lordship will find MHRD guidelines. Centrally sponsored scheme to be manned by a registered society registered under Societies Registration Act. And Nagaland Education Mission Society, they are governed by bylaws and memorandum of understanding. And the names is formed and registered under the Societies Registration Act. Mission director, he is normally a bureaucrat, now it is manned by a woman. Day-to-day activities are implemented under the supervision of the mission director. Now, here, the chairman of the society is the chief secretary. And the prayer of the writ petitioner, in the writ petition, page 30, Lordship, they are seeking a direction to the chief secretary to constitute an inquiry to inquire into the mismanagement, diversion, misappropriation of salary of the petitioners. And the chief secretary is respondent number 1, who is the chairman of the society. Now, whether the chief secretary can be appointed as a member, or he can issue an order to conduct an inquiry against him.
Yes, I'll give you an answer. I'll give you an answer.
Chief Secretary cannot constitute a committee, and the prayer of the petitioner is to constitute a committee to inquire against the Chief Secretary. And Chief Secretary is the chairman.
I'm not being able to get it right now. There's a history of judge, I think, in United States, was 2 minutes late in coming and attending the court. He imposed a fine on himself before he sat on the chair. Forgetting the name, I've just now unable to retrieve it.
Now, Lordship, why I'm
So
referring to
if,
the
if a
prayer
chief
portion
secretary,
is-
if a chief secretary in his capacity as an administrator finds that under the Samagra Shiksha funds have been diverted, he can still do it. There's no bar on making an inquiry.
Lordship, if at all, it is so necessary to conduct an inquiry, that is open and will be the happiest person. But it will be just a wastage of common machinery and wastage of time. Because in order to do that, the petitioner should come out with the concrete findings that, look, this is how the fund has been received, and this is how they have misused. Clearly, they should come. Yes, in such eventuality, this honorable court has the power. Yes, conduct an inquiry. That can be done. But just a well allegation has been made, and to conduct an inquiry on the basis of such an allegation, it will be a wastage of time, and it will be a futile exercise, Lordship. Why I'm drawing your Lordship's attention to the prayer of the petitioner is that there are 5 prayers in the writ petition. The first prayer, prayer A and B. This were the orders which was already adjudicated in the earlier proceeding, and the decision has already been given. That is the reason why I'm referring to the principle of Stockholm also, and the principles of res judicata. A and B cannot be granted in view of the earlier order. That is one. Earlier litigation. The third is prayer C, that is to constitute
just
an
a-
inquiry committee to inquire into the mismanagement.
just a
of-
minute. Just a minute.
Page 61 and 63 were the orders by which they were not given extension, and that was challenged in the earlier litigation, and the direction has already been given.
It is 6/6/19. This writ petition 159 is by same set of people. Page 70.
It's 70. Same, 26/6/2009.
No. Petitioners, set of petitioners are same.
Yes.
No, I think petitioners are different.
Lord Chair, may kindly come to page 21 of the writ petition.
21.
Yes. This is their statement, paragraph 31, page 21. Paragraph 31. Has the Lordship got it?
Yes.
That the petitioners were not paid off their salary for about a year, even though they were actively performing their duties. Therefore, the petitioners approached this honorable court by filing WPC numbers. Several writ petitions were filed, and we are confining to the last petition, that is WPC number 188 of 2019. The petitioner sought for payment of salary and also for extension of service. This honorable court, and the result of the letter dated 29/5/2019 and the notice dated 26/6/2019, drew the conclusion that the state respondents have financial constraints to meet the salary of the petitioners and restrained from issuing any direction to the state respondents under Article 226 of the Constitution, White Order dated 10/9/2019. All the writ petitioners were disposed of on the same day, that is 19/9/2019, except for WPC number 188 of 2019. We are concerned with this, which was subsequently filed only for salary for the duties performed White Order dated 21/10/2019, as the petitioners were of the impression that there was no fund provisions for meeting their salary to necessitate further extension. The state respondents engaged in a major foul play to hold the petitioners, including this honorable court, to believe that there is no fund provisions to meet the salary of the petitioners. This honorable court cannot turn plain eye to the action of the state respondents. Let them show which fund was diverted to which project and how. And these two orders were already the subject matter in the earlier proceeding, where the decision was already given by this honorable court, Lordship. That is the reason why the prayers, whatever they have met in the writ petition, none of the prayers can be considered by this honorable court. In view of these two principles, Stupil and the principles of vis judicata. And so far as the last two prayers are concerned, that is prayer D and E.
Just a moment.
We have also filed an additional affidavit explaining how much money was received, how it was utilized. All these are categorically mentioned in petition affidavit of respondent number 3.
Mr. Shikis is trapped by his drafting, but you may excuse it because these petitioners in 188 are not these petitioners. He has perhaps mixed up.
Your Lordship will kindly appreciate this. A group of petitioners approached the zone court.
No, that is different. You are trapped by your drafting. You are trapped by your drafting, but ultimately, in 188, the petitioners are not the present petitioners. There are 50 names I have checked.
Lordship.
They are not the same petitioners, but you are trapped by your drafting.
Hello. Lordship, on the issue of res judicata, that issue does not arise after the state has misled the zone court by placing a document on record to show that.
No, that is okay.
Yes, Lordship.
Yeah, we are telling you that you are trapped by your own drafting.
No, Lordship. Respectfully, Your Lordship, it is not so. My learned senior colleague has conveniently made a submission as if all my petitions that has been filed earlier was only asking for extension of service. Lordship, even the order itself reflects that I've asked for extension of service.
This is a drafting devil.
Hello.
It's a drafting devil which has appeared in page 22 of your writ petition.
Page 82.
22.
22.
Although they were not petitioners, but by your drafting, you have made them petitioners.
No, Lordship. There are several groups of writ petitions, Lordship. So those petitioners who approached this court by filing the WBC number 188, they are also petitioners in the analogous matters, Lordship. The analogous matters.
But the fact remains that they are coming for the second time on the same issue. That's why
petitioners then.
I am pointing out this fact.
Okay.
And whatever prayers they have met in the prayer, in the writ petition, none of the prayers can be considered in view of that. And the prayer D and E are seeking for a direction to reinstate in service. They are already out of service since 2019. We are in 2024. And that too, in view of the fund constraint, they were compelled to be discontinued. And their term of appointment was for a period of 6 months only. And especially the prayer E, direct the state respondent not to disturb. We are not disturbing because they are already out and they are peacefully engaged in different activities. We need not disturb them.
Okay.
May I give one or two clarifications, Your Lordship?
Yes, yes.
As far as the first point submitted by my learned senior colleague is concerned, Your Lordship, the writ petitions earlier filed have all asked for extension of service, except for WBC number 188, which came before the Zombie Court after the order passed in the earlier writ petitions. Because when the earlier writ petitions were moved before the zone court, they placed the document date letter dated 29 May 2019, stating that the fund provision to meet the salary component of the part-time instructors have been discontinued. Very conveniently misleading the zone court by placing a document stating that fund provision has been discontinued. So Lordship, when the WPC number 188 of 2019 was filed, it was filed only for getting the salary for the duties performed, Lordship. So that cannot be taken as an excuse after the state has already misled the zone court and the petitioners of the belief that fund provision has already been stopped came only to ask for salary. And later on, by filing the RTI application, which I have shown you, Lordship, it came to light that fund provision to meet our salary is still continuing. That's one, Lordship. So the question of res judicata does not apply. Number two, my Lord, my learned senior colleague has, for the respondent number 3, submitted that the authority to act on the funds received, on how to utilize, for exercising the discretion that authority emanates, or the root of the authority lies with the MHRD. If the MHRD has given the Nagaland Education Mission Society or any authority in Nagaland to divert the fund, here this word is very allergic to the respondents, but there definitely is a diversion of fund. If there is no diversion of fund, then why our salary component is also part of the project approval board that has already approved and has been sent to the union, Lordship, whether the total amount is received or not. Your Lordship, the document itself clearly shows that our salary component is also part of the other categories of teachers who are all in the same, overall in the same category, Lordship. Now, my Lord, my learned senior colleague was also taking an example of a family where, when the budget provision is lost, some adjustment to be made. Lordship, in that, if we have to apply that logic, then maybe out of 633, if some of us were chucked out because the fund provision is less, then that is a reasonable excuse, Your Lordship. But altogether, all the 633 part-time instructors have been chucked out, Lordship. In a pick and choose manner, we have been kicked out, whereas those under the centrally sponsored scheme now known as Samagra Shiksha, Lordship, our same category of employees are still allowed to continue. Your Lordship, where is fairness in that, Your Lordship? So if the discretion is given to the Nagaland Education Mission Society or any authority in Nagaland, giving them the discretion to terminate us, even though we are also part of the project approval board that has been approved, Your Lordship. Where is that authority? Where is the foundation of that authority? Let the respondent number 3 or the state respondents, let them show before the zone court by way of a document, Lordship, not by way of submission, Your Lordship. Whether it's a notification, whether it is a letter, any document from where that authority is emanating from, that may be placed before Your Lordship, before the zone court.
Additional affidavit will reply everything, all the queries that has clarified. Moreover, Lordship, state has also filed affidavit in opposition.
This one.
We have filed an affidavit in reply to the additional affidavit of the writ petitioner. There we have explained in detail. State has also filed affidavit. Lordship.
It's not difficult to understand. We don't need an inquiry vote for this. The
Yes.
figures appear to match.
Hello?
The figures appear to match. We don't need a, what do you call this, inquiry team to make that finding. I'll show you something.
No, Your Lordship, the
I'll show
main
you.
reason.
I'll demonstrate
Yes.
before you.
My lord.
In my commerce, I had management, accountancy and taxation as subject. I come to the affidavit in opposition of respondent number 5.
My lord. The last page.
Affidavit in opposition of respondent number 5.
Whether it's the additional affidavit.
No, affidavit in opposition of respondent number 5.
Yes, Lordship.
Tejpal Singh.
Lordship.
Please excuse me if I go wrong because I'm using my skills after 31 years of passing out my.
Now, my lord is still in a better position to understand the mathematics.
Now, in this affidavit, page 7, paragraph 13, Roman 13.
Lordship.
It says the detail of so-and-so share released in 2019-22 in respect of Nagaland is as follows. Correct?
Lordship.
Next page 8 is 1920. Central fund release is 19047.59. Correct?
My lord is page 8.
8, first
Yes,
entry.
Lordship. The first column.
Central share released is 19047.59. Correct?
My lord.
Now come to the additional affidavit of which Mr. Jamil is referring to. His affidavit. Respondent number, additional affidavit of respondent number 3.
My lord.
Come to page 7.
Annexure 10.
Annexure 10.
Lordship.
Last figure is 190.47.
My lord.
So only 53 is missing. 53 is 53,000. We can omit that. But 190.47 in crore is there. So it tallies with the figure which is given by the government of India. So the amount which is released by the government of India is reflected in their affidavit of money receipt.
My lord, if my lord sees the affidavit filed by the respondent number 3, the affidavit in opposition, there the number is shown as 119.19. That is why, your lordship, that was pointed out. But even assuming that, not going into that context,
You
your
see,
lordship.
money is being given by the Union of India.
My lord.
Union government says, we have paid so much of money, 190.47.
Lordship.
State government files an affidavit saying that we have received 190.47. End of the matter, why we need an inquiry?
Lordship, earlier, the total was not telling your lordship. So that issue was raised. However, my lord may kindly appreciate this.
Now they have given an affidavit, but this amount is telling. But you see, there is a fallout of this affidavit. If this, otherwise, if these two figures of the state and the union government tallies.
As of now, yes, it tallies, your lordship. I agree with your lordship.
No, but now you come to the affidavit of the government, central government of page 9.
Yes.
Because the one part is acceptable. The second part is that this salary of part-time instructors fall in the domain of state government. Therefore, central government makes it very clear that they are not.
No, I agree with that, your lordship. The central government has made their position very clear that basing on
then nothing remains. We have to close this petition. There's nothing to be.
No, your lordship, I will point out one point to your lordship for your lordship's appreciation. Here, see, at page number 7, if my lord may kindly come here, Roman A.
Yes.
Roman A. May I read, your lordship? It is pertinent to mention here that the recruitment, service condition, and deployment of teachers are primarily in the domain of respective state government and UT administration. No dispute, your lordship. It is further submitted that the PAB did not decide remuneration to be paid to different categories of the staff also. No dispute, Your Lordship. Now, the last line is very important, Your Lordship. It only prepares an estimate based on the state as per scheme norms. So who prepares and send to the union government, Lordship? It is the state who prepares and send.
In the pre-page at page 6, you find that figure. Five,
Yes, Lordship.
531.72 is reflected.
Roman 12, Your Lordship.
No.
Page 5.
Page 6.
Page 6. Yes, Lordship, this is for the.
In the fourth column, they are giving 531.72 for part-time teachers. So they have taken into account.
Yes, Lordship. So when they are taken into account, Lordship, and the project approval board has approved not only for this category, but in total, all the same category of teachers. How can only be the part-time instructors be chucked out, Lordship, in a pick and choose manner? How can they be the only category of teachers or staff employees, Your Lordship, that can be terminated from service and the others are allowed to continue? Similarly situated employees are allowed to continue, except and it is the state who makes the proposal and send to the union. So if they have left out the part-time instructors, Your Lordship, which totals to 633, at the end of the day, Your Lordship, I leave it to Your Lordship's decision, but.
No.
Yes,
You
Lordship.
see, if you don't want to read, I can compel you to read. But you see, this para 6, page 6, that column is there. 2019-20, they are showing the budget estimate for part-time teachers.
Yes, Lordship.
Correct.
Yes,
Now you come back to this, and they are making a statement that provision was same for all the 3 years. That is 1920, 21, 2021, 21, 22. They are saying in their affidavit that it was same. And then they say that in the framework of Sambhagya Shiksha, salary of part-time instructions fall within the domain of the state government. That means they don't say that they have approved it. They say that this is the financial outlay. Financial outlay is there. They take into consideration this.
So, Your
Central
Lordship, in
government is
other
not
words,
saying. Central government is not saying that they have not considered that.
No, my lord, Your Lordship, respectfully, my lord, if that analogy is to be accepted, is it correct to say that the state has liberty now from the project approval board, the document which I have already shown, Your Lordship? Is it correct to say that the state has the liberty to terminate any category of employees under the Samagra Shiksha, even if the fund is continuing? Not just now, it is the part-time instructors. Assuming that while the scheme is still continuing, the fund is still being granted by the fund is provided by the government of India. Is it correct to say that the state has the liberty to again check out another group of employees under the same, and then the state will not be answerable, even though their category is also included? There are many categories, Lordship, where part-time instructors are just one part. So today, part-time instructors are thrown out. Tomorrow, another group is thrown out, and then they will have no right to seek remedy before any forum, Your Lordship. That analogy, respectfully, my lord, I feel it's not very reasonable.
Okay, as far as we run short of time.
Lordship, state government has also filed affidavit. Of course, union affidavit, Lordship has already said.
Government would not say anything.
Yes, Lordship, in fact, respondent 1, 2, and 4 has got nothing much to say here, Lordship. We have very limited role here.
1, 2, and 4 has filed an affidavit. They have not said anything.
Yes, Your Lordship, we have a very limited role, Lordship. In fact, we'll reiterate the submission made by the respondent number 3, Madam.
Lordship, since the central election is also being made a party,
but
we are just a performer respondent here. Lordship, the union is just a performer respondent in petition, and since otherwise also state, the education is a state subject under Schedule 7 of the entry 2. Education is state subject. So here we have nothing much to say. Otherwise, under the Samasita scheme, the central give an amount, the contribution between the state and the central is 90:10. 90 is paid by the central government and 10 by the state government. That is for the northeastern state and Jammu and Kashmir. It's 90/10. So on the basis of the funds projected by the state, the central will allocate the fund. Of course, the fund is not paid in lump sum, but depending upon the ability of the funds are released in 2 or 3 installments. Say 2 or 3. So otherwise, appointment of the teachers, whether it is primary teacher or graduate teacher or instructor, that solely depends upon the state government. That is our lordship.
Please, your lordship. Lordship argument is concluded, but just one point, if my lord may kindly take note of. The respondent number 3 has submitted that discretion is given to the state. So it is my question, from what authority they have the discretion where a particular category of employees whose names were also included as part of the approved by the project approval board, by exercising authority, which authority that we have been thrown out, your lordship, that may kindly be included in my submission, your lordship.
Okay. The positive time orders may not be passed right now, but we'll release it. Today it may not be uploaded, it will be uploaded only tomorrow. Orders will be uploaded only tomorrow.
My lord would like to pronounce the order in the open court.
No, I'll pass in the chambers. We won't have time.
My lord.
I think other matters would all be rolled over. We'll request the registry to fix these matters on being rolled over.
Lordship, item 57, 58, if time permits, can it be taken up tomorrow, your lordship? 57, 58 hearing item, last 2 items, these are analogous matter, if time permits.
Fifty-seven, 58.
57, 58, analogous matter, your lordship. If time permits. No,
Tomorrow, I think the list is already there. We may consider making it on Friday, on Thursday.
Thursday.
Thursday, Lordship. Lordship, I am appearing item number 57 and 58 on behalf of UPSC, respondent number 5, Lordship.
Yes.
They have a grievance against the UPSC action as well. So 14th will be difficult for me. Can it be on 13th, Lordship, subject to your Lordship's convenience?
I think we have a division bench.
And Friday, 14 actually, Lordship, I have a matter before Honorable Supreme Court, Lordship. I won't be able to appear.
Then Friday then.
Lordship.
Lordship, item 56 also, it is an urgent matter.
Obliged.
Okay, just give a list to the court master. I'll just take a, we'll take a call with the registry. If there's a matters, you just put it in a slip of paper and give it to him. We'll consult with the registry in that term.
Lordship. Obliged.
Or if not, then you please, if not, then please make a mention tomorrow. If not, please make a mention tomorrow. 1 year everything. Nein. Ini 4 weeks behind. Instruction di dia nama over. Change quoi? No. 21. 4 weeks.
4 years, man.
Nah, it's all right.
2 weeks.
No, for you guys, it's having a lot of problems. 4 weeks. 4 weeks.
Ata 2 weeks.
Sure.
4 weeks boleh.
4 weeks. Since I'm yet to receive it. No, the problem is since
Thursday. Buổi sáng này nó siêu giỏi thật.